Do you have any idea who is the for the private respondent?
Maybe Central Bank of India. Manager, branch manager.
Branch manager.
Let the item reach people whether notice has been served or not.
Okay, just wait. Let the item reach. Wait for some time to say that.
May I please, Your Lordship? I beg to mention item number 1, Lord. I've taken the consent from the respondent, Lord. I need the matter may be taken up after 3 weeks, Lord. I appear on behalf of Mr. A.M. Bora. I have taken the consent of Senior Counsel T.J. Mohanta, Lord. Respondent number 2.
You have informed T.J. Mohanta?
Lordship.
After 3 weeks you need. But this is a case of Muslim 2018.
Lordship, we have taken the consent for 3 weeks. Then okay, Lordship, I'll inform it's for 2 weeks.
2 weeks then?
Lordship.
This time.
Lordship, there is an interim that may kindly be continued.
Interim be continued. Okay.
May I please, Your
Highly
Lordship?
obliged.
I beg to mention item number 19, 1919, Your Lordship.
1919, yes.
Can it be taken on 10th, Your Lordship? 10th of June.
BD Kaur was there. You are for the respondent or petitioner?
I'm on behalf of the petitioner. Actually, he is out of station, and because of the weather, he is not able to arrive today.
Mr. Kaur?
Yes.
Other side, there are for the private respondents, 3 names of the advocates are reflected in the causes. Have you taken contact of the anyone?
We are not able to contact them actually, and that's because I have little knowledge about the matter, and my senior is handling everything. So
No. I'm not on that. Have you taken consent of the other side? Because you are going to pray for the adjournment.
I am here for pray for adjournment.
After the adjournment, we are going to take up because of the personal inconvenience of Mr. Kaur. So we are going to adjourn the matter, but there will be an order in the reflective that you inform the other side. Inform the other side. Mr. A. Bhattacharya is there. MMS K. Malakar is also there.
Yes,
so these 2 private respondents are there. Apart from that, most probably Mr. S. Paul is also there. So you just try to inform.
We will.
Inform who you order. After 2 weeks.
We have received the service.
Huh?
Service we have received that shall be continued.
I'm not following. What you have said?
Service report has been received by us. It was supposed to be served.
That I don't know, but as per the cause list, they have already received the notices. I think that's why the name has been reflected.
Yes.
So the service is already completed. So that's why it has come in the admission column.
Yes.
Okay. This Dr.
Highly applied, Lord.
May I please, Your Lordship? Lordship, I beg to mention item number 16.
16?
Lordship. Your Lordship, may kindly adjourn the matter for today and allow it to be listed after 2 weeks.
You are for the petitioner?
Lordship.
Why you need adjournment?
Lordship, my senior has some personal difficulties today. That's why.
Mr.
J. Chutia.
J. Chutia? Okay. Due to personal inconvenience, not with the and accordingly on his behalf, this accordingly after.
Obliged.
May I plead, Your Lordship? I beg to mention item number 28, Lordship. This matter become infectious, Lordship. 28.
Why? Is it any compromise or anything? Is there any instruction from your client?
No. This.
As per the instruction of the matter has become infectious.
Okay.
Disposed of on withdrawal as become
28.
Disposed on withdrawal as become.
Much
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 18. The matter may be passed over for the day, member.
18.
18.
This is also in admission column. We have received LCR also.
Yes,
you are for Mr.
Petitioner, my lord.
A.R. Karim.
Yes, my lord.
The other side is Mr. R. Islam and Jay Mondol.
Yes, my lord.
Have you taken consent?
Yes, my lord.
Consent probably. Okay. It will be listed after 2 weeks.
Next week?
1 week in it.
Yes, my lord.
List after 1. Was there any interim?
Yes, my lord. There is an interim, my lord.
Interim was
Let me
there?
continue.
Interim be considered. Okay.
Oh, please.
May it please your lordship, back to mention item number 37. So this matter has become infructuous now because the settlement has already been achieved, and at the same time divorce has been also granted. This is like petitioner husband and wife this matter was all about. So now there nothing remains. Already every like matter has been taken care of with that particular settlement, and since now they do not want to proceed any further. So on the instructions of my client, I want to withdraw this revision petition.
For WR maybe?
Yes.
Hard Mr. WR. And it is that as per instruction of client, the matter that the next department are not interested and accordingly
Item number 37.
as the matter has also come up. Okay, it will be.
Obliged, sir.
May it please the lordship. My lord, I might mention item 8, man. Item number 8.
Yes.
As for my information, matter has been infructuous, my lord.
Oh.
Because final report just the final has been submitted here.
I am in the respondent in this.
Final report has already been submitted.
Submitted by the court. It has become infructuous partially.
Okay, otherwise it was for the washing of the criminal.
Yes, my lord.
My lord, LCR may be sent back. Because only final report has been submitted. If Naraji petition has come, all these things,
Yes,
procedure.
that may.
So LCR may be sent.
Hard Mr. M.H. Raj Barbhuya and also hard Mr. S.K. Ghosh.
Yes.
S.K. Ghosh did not count for the
Respondent number 2.
respondent number 2 and Mr. D does not of the response. It is submitted by Mr. Raj Barbhuya that in case the police has already filed the final in this context, Mr. Ghosh did not count for the submitted that the LCR to be returned back at the earliest. Accordingly, they disposed of with the direction to registry to return back the case report.
And trial court may proceed in accordance with it.
No, that how can I say?
It is up to
You
trial.
file your Naraji and all.
Yes.
Obliged,
You may file.
Yes.
That is not the part.
No, final report has not been accepted. It has only submitted.
It is not.
That is why
he is saying that
saying.
he wants to withdraw because already FR has been submitted.
Then I have no.
In your part, you may
Then I have no objection. Withdraw, I have no.
withdraw, no objection. You file Naraji and all. That is
Obliged,
Obliged.
Item 5 and 6, my lord. These are matters for quashing of an FIR. My lord, due to some power disturbance yesterday, I could not prepare the same, my lord. I have informed the other side. Can this be taken up after 2 weeks, my lord? There is no stay as such, my lord. There is no interim.
in the other side.
Mr. P. Sharma for the private respondent.
P. Sharma.
Yes, my lord. I have informed him, my lord.
Same order. No, submitted that February support accordingly you want 2 weeks.
Wait.
This
Deeply applied.
May I please your lordship? Lordship,
yes.
back to mention item number 33. Inevitably, we could not take the steps. We may be allowed to take fresh steps.
33.
Yes.
You have not taken steps.
No.
From Mr. H.
A. Mena. F. Khan, on behalf of F. Khan.
A. Mena appearing on behalf of 33. Mr. A. Mena, a counsel appearing on behalf of Mr. F. Khan, the General Counsel for the petition. And it is submitted that some personal inconvenience, the petitioner could not take steps on the private response. Accordingly, it is some more time to take steps. So there are 2 to 30 numbers. Not subject. So from the record, it reveals that I ordered it 31st of May 2023. The petitioner was directed to take steps within within a week against the respondent. Number 2, if you object, the petitioner is hereby directed to take steps to the respondent number 30 within 7 days from the date of accordingly after to take steps because there was the order for take steps. Item we are in which number?
I'd like to mention item number 46 and 47.
46.
The respondent in person.
Yes.
They have not given the copy yet. Actually, because I've entered appearance already, I don't need the notice, and that's reflected in the order. But they have not given to serve the copy yet. We are meeting every other day for other cases, but they have not served the copy yet.
46 and 47.
And it.
In both the cases, we have
Yes. Because
both the matters we have not received the
copies.
Copy.
Yes. Because these matters can be disposed of in the initial stage itself. Hence, if we receive the copies, we can just file reply and it can just proceed.
And who is the respondent number 2? Right? Is there any respondent number 2?
Actually, the respondent number 2 is my husband, who is
Oh,
also a victim. But I can receive the copy on his behalf. No notice needs to be served extra. And one affidavit can be filed in reply. And the matter can be disposed of very quickly, actually, because it's all not accordance to law.
But as per you, he has not taken
No.
the steps on respondent number 2 also. Till now?
I no. And he doesn't have to take it. I can accept the steps for that.
Oh,
And
you are
he's
ready to accept?
Yeah, I'm ready to. And we kind of spoke about it in the last.
Yes, I can remember. Mr. Bhuya is not there. Dear Bhuya.
We did ask him, because we are meeting in other cases, I did ask him or his junior, but they've not responded yet. So if the matter is taken up at 2, inform them.
Okay, let it be at 2.
At 2.
We'll see. And we may pass the order that on behalf of the respondent number 2, you may receive the notice.
Yes, my lord. Deeply obliged. Thank you.
May it please, your lordship.
Both the matters at
May it please, your lordship. I beg to mention item number 35, lordship. Meta may adjourn for a week, lordship. Item number 35.
35. You are for the petitioner?
Lordship.
Any problem? Why?
Conducting counsel H. Borua has some difficulties today, lordship.
H. Borua.
Lord.
Conducted counsel Mr. H. Borua. Prayer is made for out. Accordingly, 2 weeks will do.
Lordship.
May please, your lordship. Lordship, I beg to mention item number 42, lordship. Kindly matter may be adjourned for the day, lordship.
42 is which criminal appeal?
Lordship.
Now, can you tell us the IA is why the
IA is for bail, lordship.
For suspension of sentence.
Only
So
for
you are
today.
taking adjournment, otherwise most probably the case is also ready, na? One LCR with 6 files we have reached out.
Only for today, Lord. Only for today.
Only for?
Today, Lordship.
No, tomorrow is not possible.
Then next week.
Okay, it's after next after 1 week. We are listing it after 1 week. How many till since when he is in custody? Do you have any? Because here it's not written. That's why I'm asking.
Since 9/11/23.
9/11/23. Okay, we are listing it after 1 week.
May I please, Lordship? I beg to mention item number 51, Lordship. So it's a long pending case, Lordship. I should able to contact with the appellant, Lordship. 51.
It is the 2014 matter.
14 matter.
What happened?
I could not able to contact the appellant, Lordship.
Appellant?
Yes, Lordship.
Now see, even if you could not contact the appellant, but you have argued the matter because it is of 2014 matter.
Yes, only 1 week, Lordship. It is.
You are Mr.
Ardev, Lordship.
Mr. Ardev did not submitted that since long enough contact the appellant and then pay for 1 week for for hearing of the matter. Considering the prayer made by the internet counsel for the appellant, matter may be listed after 1 week with the direction to proceed with the hearing next week without wait as the matter is of pending matter is of 2014. List after 1. It will be listed after 1 week and try to contact and whatever. Just because there is a memo of appeal is already there. So from there also you can argue the matter. So
May I please, Your Lordship? So I beg to mention item number 4, Lordship. Criminal petition 516 of 19, Lordship. This matter has become infractious, Lordship, as per instruction, Lordship.
As per your
matter may be closed, Lordship.
You are Mr.
J. Abbas.
J. Abbas. As per instruction from
Instruction,
the client.
yes, Lordship.
As per instructions of the client, the matter will become infractious. There up, matter will be according to the post of constitution as come. Okay.
Deeply obliged, Lordship.
Well, 22, 23, 24, my lord. Out of the same FIR, my lord.
22, 23, 24.
And 24.
All are AB.
All are AB, my lord. There's an office note, my lord. 11, my lord.
কি করে অফিস করতে
মনে নেই
অফিস তো কি
Your Lordship has already disposed one of the matter, my lord. That is BA number 643 of 24, my lord. On a Busan stage, my lord. That's why, my lord, this case again listed before your Lordship.
Why it was directed? Just can you tell us?
Hello?
My learner says, my lord, to that effect, my lord, one office note is there, my lord.
According to the office note, my lord, your Lordship has
Office
disposed.
note I have seen. Office note, that means one matter was disposed by her.
That's why, my lord, this case again listed. On last occasion, your Lordship directed to list them before the appropriateness.
The order passed by. In which date it was asked that the matter should be listed before.
The last occasion, there's an order, my lord. Your Lordship's order. The order passed by your Lordship.
Oh, Mr. Justice Robin
Fukan.
most probably.
Most of the matters, interim was granted by Mr. Fukan, Justice Mr. Fukan. So your Lordship asked to place the case before appropriateness, but according to my office note, your Lordship has already.
It was Okay. It's not.
25 তারিখে আপডেটেড কেস তারিখ কারণে হেৰি কৰিছিলে 25
What is the
এপ্ৰিল
matter about, in fact?
The money lending case, man. Money lenders, man. All are certified money lenders, man. According to FI, man, FI is page 11, man.
Under money laundering.
money
or
lending
Money
money
lending.
lending not laundering not
Money lending.
money lending some people are not lending money at higher
No. That's what. Whether the case has been registered under any section of the Money Laundering Act or the only the
no money lending act other sections are also
Other
there.
section also there, man.
Money Laundering Act is not there. I think.
76(2) of Assam Money Lenders Amendment Act.
No, is there.
7C 7C2
Seven-
money
Seven
lending
registered.
act.
It is
It
registered.
is registered.
Where is the FIR?
FI is page, my lord, 11.
811.
FI was one against, my lord, Omolendo Raskwa. I said Omolendo Raskwa is already granted bail, my lord. These petitioners are not done name against me. This Omolendo Raskwa, when FI is against, my lord, Omolendo Raskwa. And your lordship granted bail, my lord, of motion is this, of said Omolendo Raskwa. And there is a compromise, my lord, between the petitioners and my lord. That what my lord orders reflect, my lord. Your lordship order, my lord.
Money Laundering Act.
All the petitioners are certified money lenders, my lord. The certified in that effect, my lord, to that effect, my lord, certificate was issued by the Office of the Assam Registered Societies. Page 14.
Money Laundering Act is a special opportunity bail act. We do it.
Now, that money lenders, it is different, my lord. It is Assam, my lord, this is Assam.
This is money lending act prevention of money lending act that is
Assam
prevention of money laundering act
It's not money laundering.
not laundering
Not
money laundering
Money lending.
money lending act
Laundering.
in the FIR that wrong word has been stated as laundering but that is not correct
No. 7C2 is money lending.
money lending act
Do you have any?
money lenders act money lenders amendment act
Money lending amendment.
money lenders amendment act 1968 Assam money lenders amendment act
Assam money
Assam.
lenders. Yeah.
But not money laundering, money lending. Assam money. We don't have. Cook would not have. Huh?
Yes. Mobile case.
mobile ulua
And we have received the case directing act.
case there is there but one thing is there your lordship may kindly see the order dated 25/4/24
25/4.
He is on interim and his statements are not there. Perhaps he did not appear before the IO. So therefore, on last occasion, on that date, I was asked to return the CD and submit the updated case diary on 27/5/24. As per my note, I do not know whether that order is there or
No, this order is there.
yes, or 25/4/24.
Yes.
Now, updated case, no police personnel has come from this Gilamora PS, so we could not return the case diary, and therefore it could not be updated. Otherwise, almost all people are granted bail for this offence.
Many cases are already granted bail.
This is from Lakhimpur. Due to election, perhaps the office person, police person has not come. We sent one message on next day, 26/4/24, but since nobody has come from that police station, we could not return the case there.
Can it be fixed on Friday?
From Lakhimpur district, my lord, Khiramora. Otherwise, my lord, your lordship,
Their presence, it should appear before the IO.
he should appear before the IO.
According to my instruction, I appeared, my lord.
He have appeared.
All the petitioners, my lord.
And
Three cases, my lord.
let his statement be recorded, my lord. His appearance be recorded, and my lord, if necessary, he will further, my lord, appear before the IO as and when required by the IO.
Now the case is registered under 7C2.
My lord.
So do you have, where you have annexed your license?
My lord, annex, my lord. I have annex. Page 14, my lord. Page 14, my lord.
Is what
Page 14, even by 16, my lord, page 15 is a renewal, my lord.
But it was not renewed, I think.
No, renewal, page 16, my lord. It's up to, my lord, 31/3/2024, my lord.
Otherwise, is there any Mr. Dutt?
My lord, I did not find his name here. Of course, my lord, this is
In the FIR.
My lord, FIR as well as my lord, other statements of some witnesses have been recorded.
There are three, in fact.
Three.
One is Mr. Bhavan
Dori.
Dori,
Tuleswar, my lord.
Tuleswar Gogoi, and
Bhula
Bhula
Bora.
Bora. That's three.
So the case diary was forwarded to us on 22nd of April. Since then, it is lying with us.
It's okay. But is their name has been reflected in the?
No, till now, not come, my lord.
The three of them are there.
Yes.
Bhavan,
One is name, that is Amalendra Raskwa.
Amalendra Raskwa is not a petitioner. He was granted already bail, my lord.
My lord, he appeared, his statements are recorded.
Tuleswar, Bhavan, and Bhula.
Or my lord, let the interim order be continued. We will try again, my lord, once again to get the updated case diary, my lord.
The interim, which is
Interim was granted on March, 1st of March, I think.
Tuleswar was granted 5-3.
Interim KTL.
Tuleswar 5-3.
No, তোমার KTL
5-3.
5-3.
Tuleswar 5-3.
Amarendra was given bail. In fact, the informant appeared and he with a affidavit saying it was under the misconception or under compulsion he had to lodge the FIR. So that is maybe the reason why he was granted bail. Okay.
My lord.
Almost is subjected by subjected by Mr. Das Didane that though the interim was granted to the present petitioner, High order dated over. You just check the 1/2024, but
5-3.
One is 5-3,
One is 5-3,
one is
one
1-3. Three are there.
Then 3.
Side of
Tuleswar 5-3, my lord.
So and so, but the statement is not available in the case. The case died. In this context, Mr. Polika that it not subject that as per structure of his bank, he has already before the IO after pay and corporate. But the subject is petitioner is not an advantage. he is certified market and also renewed his license. His license was renewed and it was valid till
31 my lord. 24.
valid till 31/3/2024. Now you have not renewed.
Now, my lord, we are not interested.
Not interested.
My lord, now, my lord, he has not renewed, my lord, after that. My lord. The case was registered, my lord, before that.
But after the registration, his license. He is does he is section 7C2 of the Assam Money Lenders Act, Packet of Amendment 98 also does not affect against the jurisdiction, nor there is any election against him regarding the cheating or regarding and the other sections where other sections are also not affected by this. He is simply a certified market lender and deals with the market lending. However, he is still ready and willing to cooperate and in further investigation if he is granted with the privilege of the investigation. It is not Mr. Das did not submit that considering the is that the petitioner to be granted with the period fail with the petition appear before the eye and the record is set under section 1 considering subsequent case considering the also considering the fact that the petitioner certified market and the fine the case to the present with the I 70 from the according to the interim order that I do not 1 year there for 5 years so and so it thereby become safe. All are same, na?
All are same. Develop.
Yes, all.
May please, Your Lordship. The petitioner is aggrieved by an order passed under 138 proceedings, my lord, NI Act proceedings. Now, my lord, the complainant is the bank. The complainant's case is that the petitioner accused had availed a loan from the bank and in discharge of liability had issued a check got bounced, so therefore he is liable. And on the presumption, my lord, both the courts, my lord, have convicted the accused. Now, my lord, first of all, if the bank has advanced a loan, my lord, there has to be a loan account, there has to be a statement of account. Now, if your lordship kindly comes to page number 17, my lord, there is not even a single whisper regarding the loan, neither the loan statement. Page 17, my lord. Complaint, that is the complaint, lordship got it, my lord. 17.
Yes.
Lordship, this is the complaint, complainant so and so, accused so and so, so and so. Now your lordship will kindly turn to next page, page 18. Page number 18. Next. Now, first para is, it says that banking competition. There's para 2, my lord. The accused person avail loan from complainant bank and accused had issued check in favor of complainant against the said loan account amounting to so and so, so and so, so and so. Then para 2, your lordship, is the check. Next page, your lordship will see this return memo, page 19. Page 19, para 3.
Who is appearing for the respondent?
Well, the last occasion also they are not, they have not appeared. So what I pray, the names are also shown. Last orders also, last date orders also, your lordship, it is reflected. So my lord, let it be admitted and fixed for hearing, my lord.
Okay, then we will admit the matter.
Admit, yes.
Let us give one more chance.
One more. Let them leave. Let's see if they appear. Let it be admitted, my lord.
Okay, we will go in there.
Fixed for hearing in usual course.
Yes. Was there any interim also?
Yes, my lord, in time to continue.
That's the done it also for the petition. The matter is admitted for it. And matter is admitted. At least accordingly. Let it, because it is of 2019, so let it be listed after 3 weeks because we have received the LCR also. LCR is the ask with us. So after 3 weeks, it will be
in the hearing, my lord.
3 weeks, this is the hearing for. Till then, it will be become.
I'm deeply.
May I please, your lordship? Lordship, senior, our learned counsel for the petition, learned counsel for the petitioner is out of station. Kindly pass over for the day.
Who is your counsel, senior counsel?
MJ Borua.
Have you informed about this, Mr. The other counsel is name of two counsels are reflected in the cause list, Mr. Das, D. Das, and Mr. S.K. Medi. Have you informed them?
No, my lord.
We'll pass the order, we'll consider your prayer, but you just inform
Sure,
the other
ma'am.
side regarding the adjournment.
Yes, ma'am.
You are Mr.
A. Ali.
Or Mr. A. Ali, appearing on behalf of Mr. M. A. Bursa, Lieutenant Counsel for the petitioner, subject this county at this council of prayer of however the council for the they were asked to inform the response this record after 2 weeks. You just inform them.
Obliged.
Lordship, in this case, respondent number, my lord, sole respondent, my lord, already entered appearance. Let them file objection.
No, we want to file objection, my lord. In the meantime, my lord, regarding the maintenance, my lord, nothing has paid, my till date. He is working as the Assam police. He got the salary 40,000 per month, my lord, but he did not pay any maintenance, my lord, till date.
Till?
Yes.
When the order was passed?
My lord, enhancement order was part 21/11/2022. 20, my lord, 21/11/2020. Enhancement order.
And he is not paying a single penny.
Not me.
Let me ascertain whether paid or not. I could not, cannot say.
Do you have any instruction?
No instruction. But only case is that from 5,000 enhance 11,000. And respondent is hereby directed to pay 20,000 and compensation, and whether paid or not, let me ascertain whether some amount paid or not, and if not paid, whether my friend able to submit any court order. Nothing. No court order.
The verbal instruction.
Let me ascertain.
We are going to file objection.
Yes, ma'am.
Yeah. F.A. Hassan.
Okay, sir.
Or F.A. Subject. Yeah. Subject that date, the petitioner in central bank. Context of the petitioner subject that there's no such comply subject that the state of be appraised, that may be appraised. Just accordingly, what time you need?
My lord, bonus time will be granted.
1 week.
Yes, my lord.
It's October.
In the meantime, my lord, the arrear amount may be paid by the petitioner.
Let him ascertain.
Yes,
So if there is any payment,
yes.
I love it.
Bless you.
My lord, in this case, my friend appeared and for the respondents.
yes.
The case is this, my lord. They have
Service is completed, he appeared. That's why it is
Yes,
admission.
admission.
Admission for. Okay.
So it may be disposed about admission stage. Today also are. My lord, it also kindly see the improving order. The fact is this, my lord. My father had purchased about 11 acres of land in various dated by unregistered sale from the father of the respondent number 1 and their other relatives. Then what happened? There is some land, 2 acres, 2 quarters, some portion of land is a Medivatal land, belongs to the respondent number 1. Now, respondent number 1 filed a petition for attachment of the said land, for declaring possession of the said land, all the way in possession since 1971. They filed a petition alleging that they are the owner of this land, and they filed a schedule for attachment schedule A and B land. Schedule A land is the Medivatal land, belongs to them. We have no any objections. But in schedule A land, they give the boundary, wrong boundary, giving our boundary, my lord. That in northern side, our land exists, but
you purchased the land from
there from them. Then we are in positions. Then thereafter they file a petition in Lordship Calisa improving order base 17.
Yes.
Without serving any notice, my lord, that order has been passed. It appears that there is a dispute between the above named parties, that the cause of action arose on event as revealed in the petition. On appraisal of Soigov Quest non-FIR report in connection with Sensu, it appears that there is imminent possibility of this. So, accordingly, that land has been attached, order to be attached. Now, against that order, I file a revision petition. And that revision petition was disposed of, holding that, you lost kindly say, only I have pointed the relevant portions, page 24. Criminal Division Nong 15/2021.
Section 145 and 146, it was drawn up because of they tried to dispose the respondents from their land. Because of that, proceeding was initiated. Accordingly, attachment order was passed. That was attached. And thereafter, my lord, so far he has contended that may I take your lordship to page 30. Page 30. He has challenged so far this order dated 15/2022. Page 30, your lordship.
Yes.
32.
Page 30. Respondent number 2, Dorbesh Ali. He has been made necessary party. He filed a petition because he is also owner of the land, your lordship. Joint ownership. And for he has claimed that he's an outsider, but it's not an actual fact. He is also one of the owner of the land. So already circle officer has certified by issuing a certificate. May I pass it to your lord? It is there, my lord, the land documents. So far, except making mere statements, my lord, here also they have not annexed any land documents claiming that Sidwell land to be there. There is no such documents even in this petition also, except the mere statements. Anyway, so that Dorbesh Ali, already circle officer, has certified. He is also one of the owner of that land, and accordingly, he filed a petitions for vacate.
No. As per their claim, they have purchased the land from your side only.
Yes, my
Now,
lord.
both schedule A and B, they don't have any documents, land documents.
They don't have documents, your lordship. So, I will take your lordship to that order of the learned trial court in the title suit. Everything is reflected there. So he was a made necessary party, and accordingly his petition was, and because the land was attached, so he was agreed. He approached before the learned trial court for vacating the order. So accordingly he filed a petition for making him necessary party, and that petition was adjudicated. Accordingly the land was vacated. So far 146 provides that is the power of the executive magistrate. Such magistrate may withdraw the attachment at any time if he is satisfied that there is no longer any likelihood of breach of peace and tranquility. On the strength of that and on the basis of that petition, my lord, that order has been vacated so far. So thereafter, my lord, so another order, I have to be fair, my lord, Annexure 5, page 31. After entertaining that petition, making him necessary party, by this order, my lord, order dated 23/3/2022, page 31, my lord, your lordship will find the last para. In further introspection into the case, it appears that by an inadvertent error in last order of this dated Sidwell so-and-so was stated to be under possession of the Dorbesh Ali. Instant case possession claimed by any party or any part of the disputed land by means of this court's order is hereby made null and void. He has reviewed his own order, my lord. That learned executive magistrate passed already vacated the land by expressing his opinion and everything. Again, he has reviewed his own order. He has no power, lordship. He has no jurisdiction to review his own order, my lord. And on the strength of that order, they have relied. That order is, it seems to be fair to them. So far, they have not challenged this order. They have come to this Annexure 6, page 32.
No.
This order is wrong, my lord. I also accept.
Review the own order.
Yes.
Against that, most probably they have challenged.
No, they have challenged the last one, Annexure 6, page 32. It is also kind of review order. But before that also, Annexure 5, I have pointed out your lordship, page 31. That order is also a review order. Because he has introspected. He made some error, my lord. So he reviewed his earlier order, my lord. So far that is not challenged. It is not put under challenge by them. I have pointed out your lordship before this honorable court. That cannot be also reviewed. That order is also illegal. Apart from that, so far he has pointed out this page 32. Yes, that order is also illegal. I have to be fair. But so far, Honorable Supreme Court has held. I may take your lordship to the title suit for a while. I have provided your lordship's copy, that one.
Yes.
Order of the title. In my copy, page 4, down below, my lord. The running page 4. Lordship, it almost starts from the 1, 2, 3 third line. It is further stated that opposite party number 1 and 2 has furnished some photographs of some unstamped and unregistered papers having several dates, and by those papers they have claimed to purchase the Sidwell A and B land. Both the lands they are claiming, A and B land, from the petitioner Refazuddin Sheikh, and one Tarjan Ali. However, those papers do not disclose the measurement and schedule of the land, and the same are also not registered documents. So far, they have provided. That is in a mixed case in the title suit. And they may I take your lordship to page 5 of that order? Page 5. The second para, my lord. Page 5. From the above discussion and hearing and after perusal of the case record and the documents appended along with the plain, it is seen that petitioner has a prima facie case. From the copy of Jamabandi and revenue receipt, it can be seen that the petitioner is possessing the schedule land having dark number so and so. If from the LS acts of the opposite parties the petitioner is disposed from the said land, she will suffer serious injury and irreparable loss, my lord. So everything is there, my lord. Finally, may I take your lordship to page this one. The page 6. The second paragraph. I am not inclined to pass any effective order of the said land. It's B land, my lord, Tozi land. But in order to protect the interests of the petitioner and this court has been approaching seeking relief, I deem it fit to direct both the parties to maintain the schedule A land in status quo as it up to the filing of the written objection. Both the parties are directed to not create any third-party interest over the schedule A land. That's the interim. The trial court has in the title suit because the respondents approached before the title in the title suit for declaration of their possession and right title interest. So far, they have also claimed that schedule A and B, that land belongs to them, and for to that effect, they have shown some. So far, the discussion I have just gone through your lordship, unstamped some documents and some unregistered documents. It is a matter of adjudication, my lord. Now, may I take your lordship to one decision of the Honorable Supreme Court? The Supreme Court has already held. It is 2004 SEC 440, my lord. I have taken the printout copy. At page 2, your lordship, of this judgment, it is Amresh Tiwari versus Lata Prasad Dubey and another, my lord. In second page, 1, 2, 3, the fourth paragraph. While the suit was pending, sorry, I'm sorry, my lord. Page 4. Sorry, page 4. Page 4 of the judgment. One to third paragraph. The question then is whether there is any infirmity in the order of SDM discontinuing the proceeding. Under section 145 Criminal Procedure Code, the law on this subject matter has been settled by the decision of this court in Ram Sunar Puri Mohant versus State of UP and others, and this principle. When a civil litigation is pending for the property wherein the question of possession is involved and has been adjudicated, we see hardly any justification for initiating a parallel criminal proceeding under section 145 of the code. There is no scope to doubt or dispute the position that decree of the civil court is binding on the criminal court in a matter like the one before us. Counsel for respondent number 225 was not in a position to challenge the proposition that parallel proceedings should not be permitted to continue, and in the event of a decree of the civil court, the criminal court should not be allowed to invoke its jurisdiction, particularly when possession is being examined by the civil court and parties are in a position to approach the civil court or for interim orders such as injunction for or appointment of receiver for adequate proportion of the property during pendency of the dispute. Multiplicity of obligation is not in the interest of the parties, or should public time be allowed to be wasted over meaningless litigation. We are therefore satisfied that parallel proceedings should not continue, my lord. So from this judgment, it is crystal clear that whatever proceeding, that criminal proceeding, the entire proceeding will go, my lord. Nothing will survive, because already parties have approached the competent court for declaration of the possession, title, right title, interest, everything. So already the matter has been adjudicated, and the prima facie status quo has been passed in the title suit by the trial court. So the unnecessary litigation, all this, my lord, these orders, these will not remain, my lord, by virtue of this order. apex court order, and apart from that, my lord, the entire proceeding will go, my lord. That is my view. The entire 146 proceeding will go. It will not be in existence, my lord. And so far, the another one, that is Mohammad Abid, in a criminal appeal. Mohammad Abid and others versus Rohi Naresh. Your lordship will find at page 2, para 411, para 4. It is, however, an admitted fact that the petitioners have already filed a suit for injunction in which ex parte ad interim injunction has been granted by the civil court, Ghaziabad, Uttar Pradesh, on so and so day. Once the civil court is seized of the matter, it goes without saying that the proceedings under section 145, 146 CRPC cannot proceed and must come to an end. The inter se rights of the parties regarding title of possession are eventually to be determined by the civil court. So in this view of the matter, and without expressing any views on the merits, on the rival claims of the parties, we dispose of this special leave petition with the direction that an interim order passed by this court on so and so shall continue to operate, and as an interim measure till the civil court, Ghaziabad, passes an appropriate order further hearing both the parties. To avoid multiplicity of the proceeding, it is, however, directed that both the parties shall not create any third-party right of encumbrances over the property in dispute. So far, the trial court has also ordered like that, my lord. So, according to this order, my lord, this entire proceeding will go, my lord. It's liable to be, the entire proceeding is liable to be set aside. Not annexure A, not annexure B order or something like that. So far,
we have put to challenge which order?
My lord,
Page number
my
31
friend,
or 30?
He has
submitted
challenged two
my
orders.
case, supported my case. His lordship kindly see page 32 order, page 32,
Which order?
32, page 32.
Page 32 order.
But his lordship kindly see first, my friend disclosed
Cessation order also.
my lord, page 30, it is not a final order. Page 30 is lordship kindly
You have
see.
challenged this order.
Page 30 is the order, lordship page 30, next order. The OC, Primary Revenue Secretary, assists the police during the execution order. His father dies of service, status report before the next the case. First attachment order has been passed. They file a civil suit. Thereafter, one daughter will file a petition. This order has been passed that next day they will produce the status report. Then on next day, when the matter was taken up, page 31.
But
Yes.
if the entire proceeding goes, suppose.
Goes.
Then we can
Go.
go.
It will go, my lord. Even annexure 5, page 31,
that
that
is my
order
case.
will also not
My lord,
remain.
that is my case. This civil case, what is the finding of the civil case? Civil court says that they only take up the matter in the schedule A land only, because that is the Medipata. We have no claim of that land. I am claiming this is they are the owner of that land, but we are the owner of that. We are submitted all the documents there. That unregistered deed here also, criminal court also, I will submit it all the unregistered deed, land revenue receipt, all documents will produced. But illogical just only I come to here because illogical page 31 is the order. Proceeding has been dropped. Proceeding has been dropped. Illogically see. Correct rather. Proceeding has been dropped. Now illogically see page 32. How that case order has been passed? This is that. My friends are rightly submitted. There's interproceeding go. I am also on that. And there is no proceeding.
Yes, my lord.
If attachment order also go, everything is go. Only the civil case.
Everything. Even annexure 5, page 31.
And
that is a review order.
citation
also
submitted by my friend relating to civil court. The civil court
Yes.
is there. Criminal proceeding is to be dropped. Accordingly, that proceeding has been dropped.
All the order.
Vacating the attachment order. Nothing wrong has been done in the page 31. But subsequently,
Yes,
on their instance, again, their matter has been taken up, removed the matter. That order is to be set aside. Means, entire proceeding has been
my
dropped.
opinion, my just humble
This is
submission,
the
my lord, the entire proceeding will
Yes,
go
yes.
on the strength of this Supreme Court judgment. Nothing will
Yes.
remain.
This is the
Order will
then
remain.
already
And that will
already
be
clarified
decided by the competent court.
Yes. Already
Their
matter
right title to
the
interest
interim
and
order
possession.
attachment order pass have already go and already vacated.
That
Those
is
are
all.
already vacated.
Already vacated.
That order has been challenged so far by him in this.
Yes. Now already vacated.
Now the
Court bill
entire
has
proceeding
already
will
vacated.
go, my lord.
Illogically, that
Nothing will remain.
that order has already vacated in page 31. Page 31 illogically.
Then you have challenged that order.
Yes.
Page 30.
In null and void. Already declared as null and void.
No, you have challenged.
Page 31. Already vacated. So I am not given against that, but I given page 31, 32. What are the 28, 3, 2022?
Even 31 also. I have
31
already
also.
pointed out. He has reviewed his own order. So entire proceeding will go.
He has the no power to review. That is the main thing. If that is done, attachment order also go. Hello, bless.
I have relied upon this. Much obliged.
Yes, Mr. Das, very Item 12 phase. You were saying something in the morning hour.
Mr. Das was there. He
Yes,
said
Mr. Das was there.
it has come up for admission. Yeah, I said admission. He wanted to see the order, perhaps.
Regarding the steps, I think.
Yes.
Can copy was called for, and then the last the office notes scan copy of that has been received.
Those are there.
And then but is there any other?
There is one
from
respondent.
State, any other respondent?
There is one respondent.
Satish Agarwal. Have you taken any steps on Satish Agarwal?
Your Lordship, I
No,
don't know.
government-
It is long pending case, and I joined the chamber few days ago, 2 months ago.
Okay.
My only
So
is
he is not
only
aware
exempt
of.
from
Now, as per the office note, it seems that the office note, the LCR was called for, can copy of LCR, that has been received. But apart from that, the steps regarding the steps of to respond number 2 is not there.
Very first order of the learned court may be seen there. Perhaps the notice have gone to the very first order. Because normally on the very first day only notices are issued.
In the first order itself, it is missing, in fact.
Acha.
Order was passed for.
So no
death on
notice was
respondent.
issued.
No notice.
Lordship can issue the notice
Yes,
today?
yes, we are going to issue. Your name is not there, no? But what's your name?
R. Shaha.
R.
Shaha.
Shaha.
On behalf of PK Rochuri.
Mr. R. Shaha, appearing on behalf of Mr. P.K. Rochuri. From the office note, it reveals that office note dated 18/8/2024. Reveals that the scan copy of the LCR has already been received. But LCR along with the scan copy of the LCR along with the case diary has already been
Perhaps it's the informant.
But it seems that no steps has been taken.
Respond number 2.
Nor any order was passed to that extent. According to the petitioner, he have directed to take state content for number 3 as after this matter according to
informant.
So you have to take steps to respondent number 2. Is the private respondent. As per office note, as per the order of this court, there was no order for taking steps on respondent number 2, so take steps on respondent number 2. Otherwise, we have received the scan copy of the LCR along with it. Okay, it will be listed after court.
Perhaps no stay is there. I don't know. My copy
No,
does
no
not
stay,
show.
no stay, no stay. Stay was not there. Only one advice was there. They can file a representation petition under 205 CRPC. That was there, but stay was.
Huh? 14, this is a matrimonial issue and the respondent is not before your lordship.
My lord, office note 19/4/23 shows that service is completed, my lord.
Oh,
Flag Y,
19/4.
my lord.
It's completed.
Completed. Flag Y is the, my lord, they are in the part 2 list, my lord. Part
But
2.
they have not appointed anyone.
Anyone.
No wakalat nama.
You are on in which order?
My lord, I am proceeding of CR case.
No. Kuntu order bote.
My lord, office note
Office note
19/4/20. Last part, my lord.
Oh my God. Oh, are you? Thank you so much. So many allegations in the complaint petition.
Similar sort of allegation, an FIR was lodged, my lord, just prior to 1 month, my lord. That was culminated to, my lord, FR by the policeman.
Not, no. State. There is a stay, perhaps.
Stay.
Lordship can admit the matter and Lordship can wait till they appoint someone or
Signature of Anjali. Is there the signature of Anjali? That one number 2 is Anjali Thapa. What Anjali?
Flag mark is there. Why?
Signature.
The process server's report is there that he has served it.
Photo signature and Anjali Devi. Okay, then we'll admit this one.
Mile.
And we can give one more chance to so otherwise the proceeding there is a stay order.
there is already a stay. I think the divorce
Also
proceeding is also
allowed.
allowed. They are divorced now.
Divorce proceeding is already allowed.
Allowed, my lord. She contested initially, subsequently she remained absent, my lord. And the ex parte divorce was allowed, my lord, in favor.
So now this petition is the challenge
Against
the criminal case.
Against the criminal case.
498A.
No, 498. No.
Asado?
294.
294, 406.
Oh, it's 294. Huh? The other case is
Almost similar allegation in police case, my lord. And that was culminated to FR by the police, my lord. There is no incriminating materials against the petitioner. And just after 1 month, well, she filed this proceeding before judicial magistrate Karbiang.
That in that case,
Lord.
she may not be interested.
Lord.
May not be.
We will admit this one.
Lord.
Mr. J. Lathpat. Mr. J. Yes. As per office note dated 19/4, services the notice is between duty served on but one the one number I was not the matter has been CPR can what
LCR
LCR is not called. LCR received. না এটা এটা তো দেখবা না বলছি
as the matter has already stayed, can we call for the scan copy or the case recording?
Case record can be called as the proceeding has already been
Already state.
Already stayed.
Well,
That's why we can call for
Call for the records.
call for on the final. On receipt of the LCR, it will be listed for final hearing, and with that your interim stay.
Obliged.
May it pleases your lordship. Lordship, the conducting council is having some difficulty, lordship. Kindly it may be adjourned for the day, lord.
Who is Mr. SP?
SP.
So you are for the other side.
I'm for the private respondent.
Respondent number 2.
Yes.
298A.
Challenge is merely to the charge sheet, Your Lordship. Thereafter, cognizance has been taken, charges have been framed, and now it is pending at the stage of evidence, Your Lordship.
But from court side, mostly there is no stay order.
No.
So what is the status of the present? Is there any witness of the evidence of any witnesses has been recorded or not yet?
Lordship, as far as my knowledge is, my instruction goes, on the last occasion summons had been issued, the prosecuting witness, the complainant had gone, but thereafter the accused had sought for an adjournment that day. So evidence was not recorded.
Not yet. It's accordingly it will be listed after 2 weeks.
On any date in the next week, lordship.
You wanted the date fixed?
Yes, please.
Up to one candidate can
Any day.
10
10/6, I will not be here, Your Lord.
Okay.
So, on 12th or 2 days ago.
12/6 or 12.
12th.
Deep blue.
Much obliged.
Which matter you are? You're calling?
May please, Your Lordship. Kindly matter will be fixed at 2 p.m. my lord.
PM already 2 matters have been picked. I don't know
senior is
if
on his legs,
Let it be some other day.
matters are there. So I don't know if hearing goes, then may not pick up. Who is your senior? Mr. Biswa?
Yes, madam.
I saw in the morning I was there.
He's another court, madam.
In another court. If it is not any urgency, then we can fix on the next week. Otherwise, 2 p.m. I cannot say.
I can grant my instruction from my senior, madam. And
You need for the time being, I have given.
at the time.
Okay.
May please the Lordship. Lordship, by way of this criminal petition, the petitioner has sought the challenging the NIT proceeding pending before the additional CJM court, Nagaon.
Yeah. We are on 20. So one eye is also there, na?
I has been disposed of, Lordship.
Already disposed.
Disposed of.
Okay.
Lordship
So
may
we
take-
are on criminal petition now.
Lordship may take up a criminal petition.
Okay. Yes.
The petitioner before your Lordship is suffering from a vulnerable disease called BM retroplasty. So he is urinal some sort of disease. He has undergone surgery. Now he is bedridden, Lordship. In the meantime, the petitioner has the liability of 6 lakhs of rupees towards the respondent number 2 in the instant proceeding, Lordship. And accordingly,
That is admitted by you.
that is admitted, and he has issued 3 numbers of checks, and all the checks were bounced. Accordingly, because of his ill health, he could not appear before the court on time, Lordship, and he sought for adjournment accordingly. And he was not granted time, and time to time NBW and BW were issued, Lordship. And lastly, he has challenged the entire proceeding before this honorable court. And on the first occasion itself, this honorable court has granted an interim order. Lordship may now come to.
Just tell me whether he, due to his ill health condition, he could not appear to whatever
That's
that,
right,
that part
Lordship.
you are, or you are challenging the entire proceeding.
Yes,
What is
Lordship. Lordship may come to page 8, Lordship. Ground number 4. Lordship got it. For that to underscore the law that the appearance of the petitioner can either be personal or through his advocate, the learned court below can dispense with personal attendance of the petitioner if the learned court below sees the reasons so to do and permit the petitioner to appear by his pleader as provided under section 205 of the Code of Criminal Procedure 1973. As such, the entire proceeding is vitiated for non-application of the aforesaid provision, Lordship. Then come to ground number 6. For that, the learned trial court, while initiating the impugn proceeding by exercising the jurisdiction of provisions of section 138 of the Negotiable Instruments Act 1881, would have adopted the provisions as envisaged in section 205 and section 317(1) of the Code of Criminal Procedure 1973 by dispensing the personal appearance of the petitioner as well as exempting the personal appearance of the petitioner considering his severe ill health almost a decade now, if not considered upon filing of the appropriate application, would cause serious injustice to the petitioner for continuance, which is the crux of the proceeding, cannot be ignored of the proceeding. As such, the entire proceeding is vitiated for non-application of the aforesaid provision. Now, Lordship may come to 205 of the Syracuse.
That provision is there. Now, what is your challenge in fact? 205 is also
Lordship,
there. So your 205 was not considered.
That was not considered. 317 was not considered. So I am ready to appear through my counsel because of my ill health. That is the prayer. I am relying on one judgment of this apex court. May have a look.
The matter is still pending.
My lord will kindly come to page 42. Their petition. Case, my lord has it. My lord, case is was fixed for arguments, my lord. So everything else is over, my lord. Now case is fixed for argument. On the date of argument, accused does not need to appear, my lord. His engaged counsel can appear, do the argument. Case will be fixed for judgment, my lord. This is an NIA case. He is not going to jail anyway. In NIA case, my lord, maximum punishment is 2 years. So he will not go to jail, my lord. So I do not understand the purpose of this petition, my lord. At the stage of arguments, we will know if they file an application on the date of argument that the accused is ill, cannot appear. Advocate will represent, will not oppose that.
Whether they have cross-examined your witness.
Everything is done, my lord. Everything
What
is done.
the problem?
For argument, my lord, now. This is for argument.
Go for the argument.
That problem is,
Cross-examination is already over.
Yes,
The case matter is fixed for only for argument.
Yes.
So why don't you go for argument? In argument stage, his presence is not required, in fact. That will be considered by the court. Obviously, it will be considered.
Yes, ma'am. We are also not opposing. We will not oppose that if they.
No, we'll file the appropriate application then, Lordship, and that may be considered first, and then go for argument of the
Now,
case.
at this stage, if I say that at this stage 205 is also not required because it is an argument stage,
Yes.
as he pointed out.
Yes.
If it is an argument stage, the 205 is also required. No, I don't know. You have applied this petition. What is your prayer in this petition?
Quashing of the entire proceeding.
Quashing of the
entire proceeding. And there is also a stay order, my lord.
Now you want to quash the entire proceeding.
Yes,
my lord.
On one hand, you are saying that yes, he issued some check, may bounce or due to various reasons maybe, and you are ready to appear. Yes. And on the other hand, you are saying that entire proceeding should be quashed.
Yes,
just.
My lord, page 10, prayer, my lord. Para A, my lord. Prayer A, my lord.
That should not be it. Should not be.
Yes, Lord.
You can appear, and at best I can pass the order that if any such kind of petition on behalf of the is the supposed you submit such kind of petition, that may be considered by the court, considering your ill health and presence is not required. That we will do, so we can dispose of the people at that time. But, M.K. Bora.
Yes.
Hard Mr. M.K. Bora. Also hard Mr. S. Nawaz. Learned counsel for the respondent.
Number 2, madam.
Number 2, and Mr. D. Das. Yes, Das. D. Das, the learned additional BP, appearing on behalf of the state. If you cannot follow, just ask me. If you cannot follow, then you can. This is an application under section 2 and so it's there only. In the first page, under section 2 and so it can be swayed. It is submitted by Mr. Bora that the present accused petitioner is suffering from what kind of disease he is suffering?
BM retroplasty.
So you have mentioned
page 5, my lord.
Page
5, second sentence.
Is
second line, my lord. BM
suffering from BM uretroplasty, and he has already undergone surgery in 2020. And presently, the petitioner is unable to for any journey and walk for a long time, and cannot even drive a vehicle. Every interval of 3 months, the petitioner has to go to Chennai to change the urine tube, which was installed through the surgery conducted in the year 2020. For that reason only, the petitioner could not appear before the court below in each and every date of each and every date of the Should I write that you are in para number 5?
Yes, ma'am.
It is written that the petitioner begs to state that the petitioner is entitled to pay financial burden of rupees.
Yes, Lord. That is correct.
So, should we reflect this one also in order?
May not be recorded. If your lordship wishes to.
I'm asking you because it is already admitted in your
Admitted.
petition. That's
The
why I'm
statement is
asking.
there.
Better to avoid this. Okay. Otherwise, you have admitted. So and so. But now, where is the averment where the your petition under 205 was rejected? Is there any averment in your petition?
No, that was not there, Lordship.
There was no petition under 205, madam.
Petition was not filed.
Why he has come?
It must be in the record. Record is not there with me, entire record.
But as per instructions, do you have any instructions that you have filed?
They have filed, Lordship.
That
I
was
do not
rejected. That was rejected.
rejected. I do not have the instruction. I do not have the supporting materials on record. Because each and every time they used to file the application seeking adjournment on the ground of health issues, Lordship. That's why
Not that those petitions were allowed, or
that was not allowed.
Well, what had happened was that petitions were filed saying that because of his ill health, he was unable to appear. Initially, some were allowed, subsequently, those were rejected, and NBWs were issued, my lord. PW and NBW. So, no proper application for dispensing the person's illness as per instruction, my lord, was filed. Just adjournment petitions for day-to-day on day-to-day basis were filed.
But till now, but at present, NBW is issued against him.
That has been already
stayed,
my lord, by this.
That has already been stayed by that criminal
IA, my lord.
IA.
So, Lordship, I may be allowed to apply for a fresh, Lordship, with that appropriate provisions of law for my dispensation.
At this stage,
I to you.
Nine.
As per you, the IA was disposed of.
Yes.
And it was recalled earlier.
Yes,
warrant was
each and every day of each and every day because of his illness, and initially those were allowed by the internet frequently, considering his action. The NBW was, however, submitted by the body that the NBW has already been recalled by the order dated 28/3/2024, passed him I criminal 301 of 2024. He further submitted that the petitioner is ready and willing to appear for the return of below and to complicate if his personal appearance is dispensed by that court due to his ill health. However, by the present petition, he also prayed for setting aside and watching of the entire criminal proceeding initiated under NI case number 84 of 2015,
Yes, sir.
pending before the Learned Board of Chief Judicial.
additional cases.
Oh, sorry, additional Chief Judicial. Mr. Nawaz, for the submitted that the case is at the stage of argument, and they do not, and the respondent has no objection if the petitioner is represented by his counsel, and the Started Court to allow any petition or representation to represent the petition under the faculty. Mr. Mr. Das Bidane that state has no objection if the petition for representation allowed by the court and case for but considering submission by the constitution enter the conflict for the both sides and the material and the entire aspect of the case. I find that this is not a case where the entire proceeding can be set aside and watched under exercising by exception to power under section 480 of the Garnet Code below. It thereby up to Garnet Code below may consider the prayer for representation of the petition who is suffering from a vulnerable disease and this may dispose of the matter here in the argument of as argument. Above observing
My lord must fix a date for the because the case has been stayed, my lord. So my lord fix a date for 15 days, my lord.
The next date is fixed on 14/6, Lordship. For necessary order.
For the part that they were for the court below on 14/6/2024 as on date fixed by the Court of Additional CPF now.
Interim order stands vacated.
Interim order stands vacated, but your NBW was recalled, no?
Yes, my lord. That part has already been recalled. That was
okay. Okay, you appear before the court and
Obliged.
make it order.
I'm deeply obliged, ma'am.
Now, please, Your Lordship.
Yes.
The cabinet petition for Jimma of 22 number of cattle.
Jimma?
22 number of cattle.
Number of cattle?
Cattle.
Now kettles are presently under Jimma of that any organization?
Yes, Lordship. It is organization, and last occasion, Lordship, the report from the police was called for. That was received.
IO report.
IO report. IO report. That.
You claim yourself to be the owner?
Owner, Lordship. I've already submitted my receipt, Lordship.
So you are Mr. Khairul Islam?
Yes.
IO.
So, it's to adverse report.
Adverse report, Lordship.
Lordship,
And
so far as
Lordship, even in the petition, this is the paragraph number 7 of the petition, Lordship. This is the page 5. May I read it out, Lord? That the content of FIR which has been lodged by the Samaguri police is totally false and fabricated and concocted story. The petitioner was not aware of the fact that the said cattle were carried by oil tanker. He came to know of the said incident when he watched the television news. Thus, petitioner has not illegally transported the cattle, nor he has any intention to theft. In fact, he is the registered owner of the cattle and he has money received for weekly market data effect. Moreover, when cattle were seized by the Samaguri police station, money received were submitted, but police refused to say. Only that much statement is there. Nothing beyond that, how the transportation was made, where and how. Only the part of the submission from the side of the petitioner is that he purchased, and even that is the carrier by which the vehicle was used. There are two numbers. Lord may kindly
Number
produce,
plate.
and everything what seems that it is a kind of nexus. So from this part, Lordship,
So
we
far
didn't find any.
so far as
evidence.
Zimma is concerned, Lordship, I have relied on judgment, Lordship.
Judgment is okay. But
Yeah,
the question is, your claim is not supposed to be a genuine claim. As per the IO report of the IO. Do you have any the way the cattle were actually
In fact,
carried?
Lordship, I am a businessman by profession, Lordship. I am businessman by profession, and
If
those
you are
cattle
a
were
businessman by profession,
Lordship.
can carry those
Those
cattles in
cattle, Lordship, I am not aware, Lordship.
in a oil tanker. How
Oil
can you?
tanker, that is surprising, Lordship. That is very surprising.
Surprising for you also.
Myself
you are the
also,
owner,
Lordship, I am not aware, Lordship, that those cattle were carried by a oil tanker, Lordship. I am not aware, Lordship. It is admitted, Lordship, I purchased those cattle, Lordship. Purchasing is an admitted fact, Lordship. But I am not aware, Lordship. Those cattle were carried by this oil tanker.
So who carried this for you? You
So
are the
far as
owner.
my knowledge goes,
you are
Lordship,
supposed to carry those cattle to somewhere.
somewhere, Lordship, to my house, Lordship, actually. To my house. Those cattle were carried to my house. But those cattle were carried, so far as my knowledge goes, Lordship, the vendors assured me that those cattle were carried. We will deliver those cattle to you. But somehow, those cattle were found in the oil tanker, Lordship. I'm not aware, Lordship, those cattle were carried by those oil tanker. Because how oil tanker carried those cattle, Lordship? This is my business. I'm already doing this business for last 20 years. So how can I know, Lordship? Those cattle were carried by oil tanker. It is very surprising. I myself surprised, Lordship. I myself surprised, Lordship. The oil tankers were carried those cattle. As I'm a registered owner, I went to the police station, Lordship, to claim the cattle. So during this investigation, there is also, Lordship, may allow this petition, Lordship. There is judgment is regarding that judgment is there, Lordship, under 457 CRPC, Lordship.
Judgment of 457 church is there.
There, Lordship.
But the way they were carried
That is
in an oil tanker.
very unnatural, Lordship. I admit it, Lordship. Very unnatural, Lordship. How oil tanker carried those things? But this business is, I'm a Lordship, old businessman. Doing this business for last many years, Lordship.
So since many years you are carrying those cattle in an oil tanker.
No, Lordship, not track, Lordship. But now this happened, and subsequently I was I'm suffering a lot, Lordship, because those cattle were I purchased those cattle. Big money involvement is there. Now I'm in financial crisis, Lordship, because I took loan from many people to purchase this cow. They are now claiming
Have
those
you appeared
loan.
before the IO also regarding those things? Have you appeared before the IO?
Lordship, in fact, Lordship, I appear before the IO because Lordship, I have already filed one anticipated bail application, and that application, Lordship, I have got interim protection, and I have already appeared before the IO, and in fact, I have submitted the original receipts before the IO, Lordship.
It's just
My
CD is
statement has
also
already
available,
been
no.
my statement has already been
CD
recorded.
is not available.
CD in
This
this
is not
regard,
called for, Lordship.
that was not
Not called for, Lordship.
That was not called for. And even, Lordship, the statement regarding the part of transportation, That is not clear from the petition. Even on the paragraph number 5, what is stated, it is only the part of the purchase. That the accused petitioner is a businessman by profession and the said business of carrying of cattle were run by him for a long time. The accused petitioner business is that he purchases the cattle from various weekly markets and thereafter supply them to various
I'm
places.
annexed
So
receipts
if
also
a
not.
person for a long time who is doing a business on that particular subject and he has no knowledge how it should be carried and
Lordship,
whether it is
only
carried or
for-
not,
this
the
is the
statement
first-
is not there in the
Lordship, this is the first time, Lordship. It happened, Lordship.
no statement in this regard. It's a
Lordship,
vague statement.
this is the first time, Lordship. This is the first time, Lordship, this happens, Lordship. Earlier never that incident took place, Lordship. In fact, I have annexed the receipts also, Lordship. Lordship, may I say, a paragraph from 2 to 14 is my receipt, Lordship. Page 12 to 24, Lordship. All are received, Lordship. Had I been not the owner of registered owner, how can I procure that Lordship receipt? My name is there, Hairul Islam. I'm a genuine buyer, Lordship.
Lordship, even in the report, I think I have put the question regarding the receipt also, whether it is genuine or not.
Police are always taking those pleas, Lordship. That is not a big thing, Lordship. Police are always doing these things. They are not genuine. In fact, they are not itself genuine, Lordship. Police.
Not consider police as genuine.
Lordship is aware of those police, Lordship.
Anyway, Bush, I'll go by the order and
Yes.
pass you.
Lordship, I may pass over this order, Lordship.
You stress on which para? You want to press on which para?
Paragraph, Lordship, may kindly say that this has been last paragraph, Lordship. Last paragraph. May I read, Lordship? In view of the reasons stated above, we answer a reference by holding that at the investigation it states these articles cannot be released by a court under Section 451 CRPC. However, under Section 457 CRPC, Criminal Court has the jurisdiction to give custody of seized property articles at the stage of investigation when those seized property are not produced before the court. Yeah, investigation case itself, Lordship, can, in fact, Lordship, this investigation may go for years or years, Lordship. But those cattle were there. So, considering all aspects, Lordship, kindly allow my petition, Lordship, granting these cattle, Lordship. Because petitioners are suffering a lot, Lordship, being a genuine owner, purchaser, Lordship.
Oh. Order passport.
Obliged.
May it please your Lordship. Lordship, the appeal filed by CBI against the order of acquittal by the learned special judge CBI. Leave
Against the order of acquittal?
Yes, yes, Lordship. Lordship, leave may be granted. Lordship, LCR may be called for, Lordship. Appeal may be admitted. There's sufficient grounds which will prove the fact that the trial court order is erroneous, Lordship. There's a delay, Lordship. It has already been condoned, Lordship, by this honorable court, Lordship.
Now,
Fact of the case is that, Lordship,
notice was sent to respondent.
Yes, yes. They appeared also on the last occasion. They appeared and they argued in the IA for condonation of delay.
But now they are not appearing.
Now you are appearing for.
I'm appearing on
Jet Kamar was the counsel for the respondent, Lordship. Jial Kamar.
So where is he now?
Ma'am, I thought he's not in a position to attend the court today.
Do you have anything to say? No. Because this is a criminal, leave petition.
Leave petition.
If can be granted from your side, if there is no objection, we can leave. Or if you want to raise something on that regard, that is up to you. Now, where is he? That Kamari?
Ma'am, he's not in a position to attend the court today. He's
tomorrow he can attend?
Lordship, the leave is between the appellant and the court only.
Okay, then is there no on
They
that
cannot
regard, if
object
there
proceeding.
anything if
Lordship.
they have anything to say, that's
Yes,
why
yes.
I'm asking.
But-
So basically, what ground you have taken?
Ground,
Is that-
Lordship, may I take your Lordship to kindly the appeal, Lordship? In appeal, Lordship, we have set out the ground on which the court below has acquitted, Lordship. In page 5 of the appeal, Lordship. Fact of the case is that the respondent herein, she was a BDO, Block Development Officer, Lordship. She, in connivance with the executive engineer of that block, they, by submitting certain forged documents, they misappropriated fund, Lordship, of the government of NREGA scheme, under NREGA, without executing any work. That is the allegation, Lordship. And Lordship, altogether 20 witnesses were examined. If your Lordships go through the evidence of all these 20 witnesses, it will clearly show that work has not been executed and bills were forged. There is no certain shops which has, submitted the bill. So those bill has been countersigned by this respondent, Lordship. So that is the allegation, and it has been proved, Lordship. But however, Lordship, on certain inconsistency of the evidence, Lordship, the trial court has acquitted, Lordship. I have set out the ground, Lordship, on the basis of which, Lordship, the trial court has acquitted, and also, Lordship, disputed those grounds why should not be acquitted, Lordship. They are in the appeal, Lordship. Your Lordship can have a look.
You are Ms. T.K. Sharma. MS T.K. Sharma. For the respondent number. For the respondent. This is the criminal leave petition. Under Section 378 of the CRPC, Vacancy Implement Judgment and Order 31/10/2017, passed by Learned Special Judge CBI number 3, CBI number 3 in special case number 09/2013 under Section 120B, 409, 420, 468, 471 IPC. Read with Section 13.2 and read with Section 31 small c and small p of this Act, whereby the respondent was acquitted in a case of misappropriation of funds and safe harbor activity. It is submitted by Mr. Halloy, the learned standing counsel for CPI, that there was sufficient material against the present respondent, who, being a PDO at the relevant time of incident, had misappropriated NREGA funds and countersigned to false bills which were submitted for accordingly the present the petition is been filed. And accordingly, the criminal appeal has been preferred against the order of acquittal passed by the Learned Petition. Considering submission made by the Learned Standing Counsel, Mr. Habib, and the grounds set out in the criminal connected criminal appeal, the leave has been granted to file the criminal appeal against the order, judgment and order of passed by the Learned in collective petition. Registry is according to the registered and numbered criminal connected criminal. Okay, your leave petition is
Hello. Lordship, let it be cash memo / voucher instead of bill. Cash memo?
Cash memo.
Yes. Instead
bill
of
जो आपके लिखा fill out for any catch memo of the
Voucher.
voucher.
Highly of
May I please Lordship? As per office note dated 4/10/23, service has not been completed.
On respondent number 2, no?
Yes, Lordship.
You want to await, or because now see it seems that you have taken steps on the respondent number 2. You have not taken steps, in fact. You were directed to take press steps on the respondent number 2 on file order dated 17/3/2023. But as per office note, it seems that you have not taken any steps. Take steps.
Okay, Lordship.
Where? Receive back. What is going to collect?
Receive back हो गई है.
Both sides are duly represented. What?
Receive back 24/5/2023 slap issue notice basically.
26. State. We have taken state 2023 then. Now it's 24. So take precedent.
Okay.
Hard sequence. As per office note, it reveals that neither AD card nor the unserved notice in respect of respondent number 2 has been received. To press notice on respondent number registered AD financial process. Also call for the scan copy to remind this
May I please,
Yes,
Your Lordship?
service is completed. Na?
Completed, my lord. LCR is in receipt.
LCR is also received.
Matter may be come up for hearing column, my lord.
You, Mr. ASIB.
ASAB Kabir, my lord.
Part Mr. SAB Kabir, the learned counsel for the petitioner. Also heard Mr. KK Victor, the learned petitioner, the respondent. Service is already completed. Full names of three counsels are already been reflected in the policies. Scan copy of the LCR has also received. No, it is a scan copy or the LCR? I think LCR. Scan copy of the LCR has already been received. List the matter accordingly in the hearing column. It will be listed after.
Good. Deeply obliged, my lord.
May I please, Lordship? Lordship, my senior out of station and could not return due to cancellation of flight. So, Your Honor may be kindly adjourn this matter.
Adjournment will come later on, but the question is the notice issued on sole respondent is still awaited. I think. So it may be awaited till next date of listing.
All right.
Otherwise, we have received the scan copy. Na? Records are already been received. Names are there. Ocha. Service is awaited, but names are shown. Okay. We are which number? 29. 29. You are Miss?
M. Narzar.
M. Narjari, RMS M. Narjari, Tiran, Constable. And state is not there, no? As per office note, the notice is not returned to the issued on the full respondent. However, names of 2 advocates have been shown in the call. LCR we have received, no? LCR has already been received. This is the matter accordingly. I hope adjournment lagana keep. They need the adjournment. It will be listed after 2 weeks. Otherwise, full respondents was awaited, but 2 names are already there, so service may be completed. Right? It will be listed after 2 weeks.
Okay, sir. 30. Well, in this is the criminal petition, my lord, which has been filed for quashing of order dated 12/1/2021, where cognizance was taken in a POXO case. Case under POXO section 6 and POXO, my lord, section 6 and 306 of the IPC, my lord. There's a stay order, my lord. Now we have filed our wakalat number, we have appeared, my lord. So, my lord, let's fix a short date for admission, my lord. Service is completed, my lord, so it may be fixed for admission.
So you are for the respondent number 2?
Respondent number 2, my lord.
State is also there?
State is there, my lord.
Is there any stay also? No.
There's a stay order on the last. Before our appearance, my lord, there was a stay order which was granted.
Stay order is passed.
So matter stay was there?
Yes, my lord. Last day stay
Well,
was
for further proceeding of the case is straight.
Why? The POXO matter.
Well, POXO matter, but the proceeding was going on, and my lord, the case we have challenged the entire proceeding, my lord. The court has
The
heard, my
petitioner
lord,
here
and
is my lord. Petitioner is an advocate, my lord, and one girl, he was in a relationship with a girl, my lord, minor girl, my lord. She committed suicide, my lord. That is the main allegation. So, my lord, may fix a date for admission, my lord.
Otherwise, appearance is complete.
Appearance is complete, my lord.
You are appearing for you are Mr. A.K. Gupta?
Yes.
Hard Mr. A.K. Gupta, you can counsel for the petition. So hard. Mr. S. Nawaz for the respondent number 2 and Mr. A.K. Bachchan, the National PP, appearing on behalf of the respondent. Service is already completed. Do you need any
Date, my lord, for admission.
No.
LCR is received. Scan copy is received.
Scan copy of the LCR has already been received. List the matter for follow. How many weeks did you know on?
After 2 weeks.
After 2 weeks, my lord. But date may be fixed, my lord.
Date.
Date, my lord.
What
POXO
any
matter, my
date? Date can be fixed.
14.
Accordingly on 46.
My lord, there is interim order that may be continued.
Interim order we continue till next.
From deeply obliged, my lord.
Make it your lordship. Lordship, by office note dated 13/9/2023, though the service on the respondent number 2 has been completed, no one has entered appearance.
So he has already entered. He is for you are for the petition.
Lordship, I am leading the matter, Lordship. Lordship,
You want to sit for some time?
no, Lordship, sir. AD card
The matter was already admitted. in fact.
already admitted, Lordship.
And no counsel entered into appearance on behalf of respondent number 2. That means it is the notice has already been served.
Some other person has received on behalf of the restaurant number 2, Lordship. That is the concern. Auction 8227.
This is not a POXO.
No, it is a revision against conviction. 270, 27 and 337, 427.
Oh. Otherwise not required, not mandatory. That they should be served with the notice.
Now, if they have made them a party, the notice will go. But then,
Notice, as per him, notice has already gone.
oh, acha.
And it was, it most probably received by some other person. Not
Some other male person in absence of the informant can be permitted. Lordship can proceed with the hearing in that matter.
Already the accusation is in previous bail. The sentence has been suspended. It may be heard in due course. Also.
The relation is not mentioned.
Relation is not mentioned, but the surname is similar. Sankari Sen. The response number 2 in Pradeep Sen may be related.
Sankari Sen. Maybe related or
Maybe related.
Of the family, because section 62 perhaps of CRPC says that any person of the family.
So in that case, relation, if relation was there, then it's okay.
Yes.
But relation is not, unfortunately, relation is not mentioned.
Not mentioned. Let us hear the matter, then we may proceed. They may not
can proceed.
Interim order is still disposal of the instant petition.
Interim order was still disposal of the interim petition.
Kiman conviction is
6 months.
6 months. 6 months is the conviction. Lordship will fix it up for hearing.
We are on 36. Huh? 30. Hard Mr. Gita, Council for the Petition. Also hard. Services seems to be complete. Elsewhere has already been distributed accordingly. Final hearing column. It is 22 matters, huh? After court. As of it, 22 interim. We should any mention
in the
if it was already there.
It's already there, need not be extended or anything.
And in the IA, he is allowed to go remain on previous bail. So IA is also
disposed
also
of?
disposed.
Court. He is already in previous bail.
Yes, that's it.
Lordship is not feeling well.
Yesterday or day before yesterday, Monday, my condition was so serious. I was about to be hospitalized, in fact. But somehow my family doctors are there also. My brother-in-law, sister-in-law, all are doctors. Somehow, as per their medication, I was not admitted. So Monday I could not come, and Tuesday also I was not had that courage to attend the court, in fact. So I took leave. Today I'm much better.
But then still, Lordship should take some rest, otherwise it will aggravate. There are few more matters.
More matters, we'll take care of it.
Lordship.
And deeply.
Okay. $20? $29 is over. Oh no, I'm not there in 29. 29, the state is not there. These are private parties. But then their names are, somebody had filed Wakalatnama. So it's not that service is not complete, they have filed. Need not worry, they will come Monday.
May I please you? The matter is registered for admission, madam. There is the interim order. We are continuing it. And may I pray that let the matter be admitted fixed for hearing by an early date.
Other side is appearing, state is there, but otherwise also
Yes.
for the respondent number 2, Senior Counsel Mr. T.J. Monta is there.
Yes, madam.
You are appearing for on behalf of him. So, please let us admit the matter. and may be listed for hearing. We required the LCR or
Yes, it requires. Yeah.
it is required. Whether we not
Yeah,
receiving it, then it is not called for, I think. So, case diary is required, I think, na?
Yes, case diary.
Case diary.
Yes.
Okay. Earlier, most probably, case diary was received, but updated case diary was called for.
Yes.
So, that may be. Heard Mr. Latif regarded counsel for fit, and also heard Mr. You are Mr.
You Khan.
You Khan appearing on behalf of Mr. DJ Mohammed, senior counsel for the responsible. Also heard Mr. A.K. Sidar. Considering the submission made by the counsel that would get call for the updated case there. Was interim was there?
Yes, interim is there.
Interim be continued with next set of listing. This accordingly. Center call for the case diary, updated case diary.
Yes, development.
It will be required.
Yes.
Yes, again there.
We have informed them and they agreed upon to come, but they have not appeared for some reason again.
For 5-10 minutes?
Yes. We'll just do.
May I please, Your Lordship? Lordship, in this case, 4 times I have taken steps on respondent number 2, my lord, but yet the notice has not served. As per office note, my lord, 5/8/23 and 27/1/23, neither the unserved notice is returned nor acknowledgement received is returned, my lord.
Was there any order to take fresh steps on respond number 2?
My lord, last time
Because one office note is there on 19/10/2023 that no.
one office note is there. Yes, my lord.
Yes.
Usual
so
process,
As per that office note, you have not taken steps.
my lord.
As per that office note, no steps has been taken.
Maybe, my lord, and it may be lapsed, my lord, without my knowledge. Actually, inadvertently may not be taken, but otherwise I have taken, my lord. My lord.
Yes, it is reflected on the 5/8/2023. You have taken steps.
My lord, my lord. And I have the receipt 2 times. I have taken steps. I have the receipt, but office note I have taken 4 times, my lord, steps on this case.
So, what do you think?
My
We
lord,
process.
my lord, as per
Let us do one thing.
My lord.
We can issue if AD is not available or AD is not returned. So let us issue notice to jurisdictional police station.
My lord.
That will be routed to the office of the public prosecutor.
My lord.
That can be done, I think.
My lord.
Otherwise, this for the order, last order, that is the same order that petitioner will take precedence. That is the order.
My lord.
So let us take steps and if let us see what is the petition in fact. This is the petition.
My lord, this is
36.
30.
This is a condonation petition. Or
Continuation of delay. 76,
how many days delay?
76 days, my lord.
76 days.
Yes, yes.
So let the process be completed. If it doesn't
My
come, then we may be
My
materially
lord.
harder. You are Mr. You are
M.U. Ahmed.
Mr. Aminu Ahmed, Internet Conflict, Internet. As per office note, dated 19/10/2020, no press has been taken on the response number 2 in pursuant to order dated 9/8/2022. However, it's Mr. Ahmed that on 4 occasions a steps has been taken for the response number 2, but no aid has been done. Reached considering the very for the petty that fits notice the number to the only of the concerned with the public seems to be taken this record. Last time we take step. 76 dated may be controlled.
May I praise Lordship?
Yes.
I am appearing on behalf of the sole respondent, Lordship. NCB has filed the leave petition, but copy not furnished till today. Lordship may kindly direct to furnish a copy of leave petition along with appeal memo within 3 days. I have to file objection in this case.
An appears to call for the petitioner as NCB. However, Mr.
US Borgo
appeared on behalf of both the submitted that no
copy of leave petition
copy of the leave petition
along with
leave
appeal
petition,
memo.
no. Copy of the leave petition along with the criminal memo of the criminal not with parties to the respondent and got paid for adhering to the NCB party of and applying him by that your that party of as well as the of appeal memo. It's about 3 weeks.
2 weeks, Lordship. Oblige.
Lordship, in this case, as per order of the Honorable Court, we have taken steps for Dusty service, Lordship, that is refused by the opposite party, and we have filed also our affidavit, Lordship, that is on record.
Dusty is refused. Why it is refused?
Lordship, we have petitioner before your Lordship file a petition under section 94 of the CRPC, praying therein that his car was stolen away by the unknown miscreant, and accordingly order was passed, learned magistrate issue warrant, search warrant, and thereafter it was recovered, and while it was supposed to send it over to the petitioner, in the meantime opposite party filed a revision petition, and thereby it was order passed by the learned magistrate was stayed, and after hearing both the parties, the revisional court remand back the matter to the learned trial court. Before the trial court, after remand back, both the party appear, but learned trial court fails to pass any order because of the fact that he filed another title suit, Lordship. Opposite party. That is, Lordship, kindly have a look at page 27.
No, it's okay. So now, what is the reason why they have refused? That's what I am asking.
Lordship, it is not known to me why it was reported. Lordship, kindly have a look at page 27. What is the pleading in the title suit? of the opposite party. Kindly have a look at page 27, para 1 and 2. It is the title suit filed by the respondent number 2, Lord. He filed a suit against three other persons, Lordship. Page 27. We have received notice from the learned court. May I read, Lordship, para 1 and 2?
Saying that what said they did. Follow group. What said. It's written in Bengali.
Lordship. নিবেদন এই যে 11/12/2023 ইংরেজি তারিখে অনুমান 1 ঘটিকার সময় আমার নিজ লিখিত ব্যক্তির বাসস্থানে আসিয়া তিনিকে উপস্থিত পাইয়া নিম্ন স্বাক্ষরকারীর আগত নোটিশ তিনি Lordship, I am not able to read.
I am also not in a position to read what he had written. Any such words? Amita Nibona Pakiba.
Yes, Lordship, it is there. It is there. Lordship, তিনি দ্বারা সমজিয়া রাখিতে তিনি অস্বীকার করেন। সমজিয়া রাখিতে অস্বীকার করেন। এই লাস্ট সেকেন্ড লাইন অস্বীকার করেন।
তিনি অস্বীকার করে তারা কপিটা দিও। এটা অস্বীকার করে।
It's not so much legible.
Legible, but
Anyway, it is Osikar correct.
Oshikar is there. Oshikar is legible, but illegible other part. Koren is not so legible.
Dusty was allowed to you, na?
Lordship. By the order dated December, Lordship, 2023.
2111.
Lordship.
It is sole respondent. I mean, respondent number 2.
Lordship.
Your state is respondent number 1.
State respondent. Yes.
Civil code.
Not going to hear the matter today because the report is
Lordship.
coming today only. Can you give us one photocopy of that report? We can keep in the case record because otherwise we don't have anything to in the record where from it can be presumed that
Lordship, we have filed affidavit. We have filed affidavit.
Affidavit is there,
Lordship.
but report is not there.
Lordship.
Just you can
Lordship, one copy, Xerox.
Copy, photocopy.
Lordship.
1239. Card Mr. L.R. Mojum, Ilanet Council. The petitioner has already filed the additional affidavit in regards to service of the notice to the court, wherein it is stated that the respondent number 2 used to accept the notice. Accept the notice. Accordingly, the service is deemed to be notice is deemed to be served on the respondent number 2. Is the matter accordingly in admission column after 2. It will be listed in admission column after 2 with CD. Otherwise, it deemed to be served. We mark it as a deemed served.
A copy of Xerox copy I will furnish.
Fine, we will keep it in the case.
Online.
May I please, Lordship?
For objection, someone has filed some more time for filing objection by the respondent side.
Respondent side.
B. Sharma. Mr. B. Sharma.
My lord, this
Today
is
he is absent.
I am, my lord, long pending case, my lord. My lord. During this time, my lord, they have found sufficient time for filing objection, my lord. Till date, my lord, not filed.
But today, why he is absent? Have you made any? Mr. B. Sharma was appearing on behalf of the respondent. Otherwise, state is also one of the party. Why I is for what?
For bail, my suspension of execution of conviction, my lord. 10 years. Yeah.
10 years.
Conviction for 10 years.
No. It is B. Sharma means your additional people.
Yes.
They supposed to file the objection.
3 years.
10 years.
3 years completed.
10 years. 10
years.
10 years. Is it prepared?
Not so. We may allow some time. In the meantime, we will file the objection.
Because it is 10 years conviction, so you
Yes,
should
yes.
file otherwise written or oral, whatever.
Yes.
But the question is that have we? LCR we have received already.
Yes.
So he can file application.
Yes.
He is how many years he is in custody? Is that 3 years?
Just 3 years, 3 months gone, my lord.
He is in custody.
Custody, my lord.
Under which section case is?
376, my lord.
376. Is there any POCSO is also there? No.
POCSO was there, but conviction is ultimately given under section 376, my lord.
So we have to give an opportunity to the other side, state to file their objection.
Short time may be given, my lord, 1 week, my lord.
Yes, tell us what, how many, within which time, or who is
we will
handling this case. Then
yes.
Sharma was there.
Okay.
10 days time.
10 days. Will you be able to? See.
2 weeks, Lordship. In the
We
meantime,
can fix a date. In
yeah.
fact, Hard Mr. J is come, the learned counsel for the petition. So Hard Mr. K. K. behalf of state. As per order dated 39/2023, state allow allowed time for filing their subject that 2 weeks may be only be needed for filing their prayer. Then accordingly, after 50 days, can you fix it? It would be on
90 days. 90 days is a long time, my lord. Maybe 12, my lord. Maybe 12.
Good. 14. 14.
14, my lord. 14, my lord. My lord, I have some difficulty in 14, my lord. Extremely sorry, my lord. Maybe 13, my lord. One day, my lord.
I don't know. Can it be? Oh.
Oblige, my lord. Highly oblige.
My lord, matter will be taken after 2 weeks, my lord. That is the enforcement directorate matter. That is some similar cases has been pending.
You are standing counsel
ED. Yes, my lord.
Why you need time?
My lord, I have to. I did not file any objection or anything in this matter. I'll take time to file. I require some time to take to file this. My lord.
Objection.
Objection. Yes.
You are MS?
B. Borua.
RMS B. Borua. You are appearing on behalf of S.
S. Borgohain.
S. Borgohain. So it's also hard MS A guy. Then
2 weeks, my
2 weeks. 2
yeah.
weeks time for 5. Recording. It is a matter of 2023 to try to file it after
Yes,
2 weeks.
yes, must oblige.
Well, please, your lordship. So this is a appeal from jail, lordship, and the appeal has already been admitted. And the IA before your lordship is a petition for suspension of sentence and bail, lordship.
Okay.
And my learned friend has already filed objection in the petition, lordship.
You have already filed.
Yes,
Yes.
objection is on record.
So, yeah, here in this case, the petitioner was convicted for offence under 22B2C of NDPS Act for 10 years.
22B C.
22B2C.
Yes, but that means the commercial.
Commercial. 43 kgs of ganja alleged to have been recovered from the house of the petitioner, lordship. And after conclusion of the trial, lordship, the trial court has convicted him for 10 years. And here the main conviction, the main ground as observed by the learned trial court, lordship, that it was seized from the house of the accused, and the said seizure is corroborated by the other independent witnesses. But here in this case, lordship, the mandatory provision of section 42(2) in respect of charge and seizure has not been followed.
Not complied.
Not complied with. And lordship, kindly come to the page 28 of the IA.
28 of the I.
IA. Yeah, I have annexed the judgment, impugned judgment here. The observation of the trial court. Page 28, para 24.
Page 28, para 24.
24, lordship.
Yes.
May I read, lordship? In the instant case, from the testimony of the informant, so and so PW5, it emerged that based on the information received, he made GD entry number so and so. However, the extract copy of said GD entry was not proved during the trial.
further, the PW6 Jyoti Prasad Das, another police officer who submitted charge sheet, has stated that he has not submitted any authorization letter under section 42 of the NDPS Act along with the charge sheet. In this regard, PW5 informant police officer has also admitted in his examination in chief that as the matter was urgent, authorization under section 42 of the Act could not be obtained. The prosecution side has also not adduced any evidence during the testimony of PW5 or 6 about PW5 regarding sending information received to the higher authority of police within 72 hours as required under section 42(2) of the Act. And now kindly come to the paragraph 27 and 28. Paragraph 27 first. One of the main objectives of the provision like section 42 of the NDPS Act is to ensure that the innocent persons are not falsely implicated for offences like the NDPS Act, which provide stringent punishment. In the instant case, the prosecution evidence reveals about recording of the information, and a GD entry was also made pertaining to the same being GD entry number so and so. However, as discussed above, there is no evidence regarding sending of information to higher police authority, and the aforesaid GD entry not extract was also not exhibited during the trial. Therefore, there is no evidence regarding the compliance with the provision of section 42(2) of the Act. Here the if during the charge and seizure, if the
what is the subsequent observation of the court?
Subsequent observation that it was a not total in compliance. Last line is that have been largely not complied with. From the premise of the accused has been proved, but the provision of section 42 of the NDPS Act have been largely not complied with. That means, according to the learned judge, it was not total in compliance. But as your lordship know, the recent Supreme Court judgment, lordship, it is a mandatory provision which has to be followed, lordship, before convicting a accused. There are judgment, I'll place it before your lordship. And in non-compliance is
the court below had relied on the Colonel Singh's judgment.
Colonel Singh says, lordship, it should not impermissible. Non-compliance of section 42(2) impermissible. There are certain exemption is there if immediate charge is necessary, but investigation officer has to give some explanation to the effect. Here in the PW5.
Who was the officer? What was his rank?
PW5 says.
No. What was his rank? Who conducted the seizing officer or seizure officer or the inquiry officer? He was the
officer in charge.
Rank of
officer in charge.
That is
inspector.
OC.
Okay. But here in this case, they received the information at around 12 noon, and they conducted the charge 3:30 p.m. So they have had lot of time to record it in the and inform the higher authority. That recourse was not done by the IO. And the Colonel Seal judgment says it should not be total not compliance is not permissible. They place the lordship Colonel Seal judgment. Relevant para is lordship paragraph 35. Here in this case, in the as your lordship no Colonel Seal judgment, the before the constitution bench, the decision arose before the constitution bench was that whether the section 42(2) of the NDPS Act is mandatory or it compliance and non-compliance is permissible or not. Here in the paragraph number 35, the constitutional bench has held that the Lordship has got it, para 35. In conclusion, what is to be noticed is that Abdul Rashid did not require literal compliance with the requirements of section 42.1 and 42.2, nor did Sajan Abraham hold that the requirements of section 42.1 and 42.2 need to be fulfilled at all. The effect of two decisions was as follows. So and so, so and so. Now, the relevant observation of the court, your Lordship will find 35D. While total non-compliance with requirements of subsection 1 and 2 of section 42 is impermissible, delayed compliance with satisfactory explanation about the delay will be acceptable compliance with section 42. To illustrate, if any delay may result in the accused escaping or the goods or evidence being destroyed or removed, not recording in writing the information received before initiating action, or not sending a copy of such information to the official superior forthwith may not be treated as violation of section 42. But if the information was received when the police officer was in the police station with sufficient time to take action, and if the police officer fails to record in writing the information received or fails to send a copy thereof to the official superior, then it will be a suspicious circumstances, being a clear violation of section 42 of the Act. Similarly, where the police officer doesn't record the information at all and does not inform the official superior at all, then also it will be a clear violation of section 42 of the Act. Whether there is a adequate or substantial compliance with section 42 or not in question of fact to be decided in each case. And after that, there is another judgment has been passed referring the Colonel 6 judgment. Here, while non-complying of section 42.2, the Honorable Supreme Court has set aside the judgment passed by the trial court on that count only.
So referring para 6.
Para 6. According to the prosecution, the respondent threw the bag in well. The suspected contraband was therefore tried to. Here in the kindly Lordship come to the last part, section 42.2, middle portion of the para. Section 42.2 requires that ground of belief so record have to be communicated to the immediate superior official within 72 hours. In this case, there is nothing to establish that the officer had followed this procedure. There is nothing to establish that he recorded grounds of his belief and communicated them to his immediate superior. As observed by the Constitutional Bench in Karnal Singh, total non-compliance of requirements of section 1 and 2 of the section 42 is impermissible. However, delayed compliance with satisfactory explanation about the delay will be acceptable compliance of section 42. Since in this case there is a total non-compliance of section 42 of the NDPS Act, the High Court has rightly set aside the conviction of the respondent. And now, why I am stating that it was a total compliance, finally come to the deposition of the PW type.
Have you annexed it in your appeal? Deposition of you annexed it your appeal, or we have to
record is there.
Record.
I am reading the prose part of the PW type.
PW5.
PW5, Lordship, kindly come to the internal page 4. Cross part of the PW5.
Okay.
Next page. The place of occurrence is about 14 kilometers away from the Pulibar police station. Before going to the place of occurrence and before receiving the information at 3:20 p.m., we got information regarding this incident at about 12 noon on that day. I have not mentioned regarding the information which I have received at 12 noon in the FIR. They got the information at 12 noon. But conduct was done 3:20 p.m. They had lots of time to record in writing and inform the superior officer, but that was not done in this case. And this is also as observed by the trial court also in the paragraph number, as I already shown to the Lordship. Now regarding Lordship, the suspension of sentence, Lordship.
Get the page, internal page number 2.
4.
No, I am on. There statement made by the
Informant.
officer that thereafter we made a house search of this so and so along with local people or that area of so and so. As the matter was urgent, authorization under section 40-20 PS could not obtain. That was the urgency, I think.
RGC Lordship, they received the information at around 12 and they conduct the search 3:20 p.m. and he was in the police station.
Yes.
And their distance between them is only 14 kilometers. 14, by reaching 14 kilometers, it will take how many time? 30 minutes almost. That is why in Colonel Singh judgment, Lordship, that observation is there, compliance and total non-compliance. And regarding suspension of sentence during pendency of the appeal, Lordship, the Honorable Supreme Court in recent judgment, Lordship, has held that where the evidence is so palpable and is on the face of the record that court can easily prima facie satisfied that there is no chance of conviction of the appellant or accused, and the conviction cannot be sustained. Court can suspend the sentence and allow the accused to go in.
Basically, you are on non-compliance of 42.
42. Others contradiction is there, but right now I cannot go into that while considering the bail of the 389. Another judgment for suspension of sentence. There is a contradiction also between PW. One is declared hostile, who is also a seizure witness, and 2, 3, 4. Their contradiction is there. The Lordship go through that. Some contradiction is there, but I am mainly on this non-compliance of 42.2, paragraph 33. Bearing in mind. Bearing in mind the aforesaid principle of law, the endeavor on the part of the court therefore should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the conviction stands for fair chance of acquittal. If the answer to the above said question is to be in affirmative, as a necessary corollary, we shall have to say that if ultimately the conviction appears to be entitled to have an acquittal at the hands of this court, he should not be kept behind the bars for a pretty long time till the conclusion of the appeal, which usually take very long for decision and disposal. However, while undertaking the exercise to ascertain whether the convict has fair chance of acquittal, What is to be looked into is something palpable. To put in other words, something which is very apparent or gross on the face of record, on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. The appellate court should not reappreciate the evidence at the stage of 389 of the CRPC and try to pick up few lacunas or loopholes here or there in case of prosecution. Here, if it is so palpable, the appellate court can. Here in this case, the appearee has been in custody for 3 years. And the disposal of the decision of the appeal may take some time. So at this stage, I am praying for suspension of sentence and to allow the appellant to go on bail petition. There is a legal aid matter, so he will appeal from jail. Obliged.
As far as section 42(2) is concerned, I think the language is little different. What my learned friend is saying that not getting an authorization will come within 42(2). 42(2) speaks of the provision, speak of a situation where the GD entry is made or reasons are recorded that authorization could not be obtained under the proviso. Then within 72 hours, a report has to go to the senior officer. This is the requirement of 42(2). 42(2) is not the issue here. 72 hours, they have to send a report. They're not talking about authorization. Authorization comes from 41 itself. 41 proviso says that authorization, if it is not possible to get authorization, if it is an urgent situation, then it may not be obtained, but regions has to be assigned. Now here, PW5 Lordship had seen, it's not a case, he had not said anything about authorization. He had said because the matter was urgent, we could not obtain the authorization. And I don't know, subject to correction, my learned friend said they came to know at around 2. But it is said that on that day, 3:20 p.m., they received the information. Kotpala. Acha, the cross part. They, otherwise in the examination in chief, acha, they said 3:20 they received the information. Okay, internal page 4. The place of occurrence is 14 kilometers away from Pulibor. Before going to the place of occurrence and before receiving the information at 3:20, we got information regarding this incident at about 12 noon on that day. Now this is subject to further cross-examination. What does he mean? He said before receiving the information at 3:20. The information he had received at 3:20. We got information regarding this incident at about 12 noon on that day. Now, what information? A prior information that relates to what incident is not very clear. Incident. Now, what incident? Otherwise, he is very clear in saying that 3:20 he received the information and he at best immediately he went with his staff members. So, as far as 42 is concerned, he got the information 3:20, he made a GD entry. Of course, that is not exhibited again, that will be seen in the time of hearing. It is not exhibited, but the fact remains he made, GD number is also there. Thereafter, he could not get authorization because he had to rush, otherwise the things will get away from the place. He rushed, he went there, he seized, he got independent witnesses. Independent witnesses are there, 1, 2, 3. They had also seen that the things were seized from, they say it is a shop, but perhaps the shop is in the residence, that sketch map will show. And that it was seized and then everything was done according to the law, inventory, taking photographs, taking certificates under 52A and all. All the G's are done. It is not a case where authorization they have not obtained intentionally. They said it could not be. And proviso provides. They'll have to specify some regions and they said it is urgent. 72 hours, that of course will have to be seen again. Whether 72 hours they had sent a report to the superior officer. That is not coming from any of the witnesses. Observation of the trial court. Page 28. Let me just check it whether that part is there. Page 29. Page 42. No, this is what my learned friend read. This one I heard. But 72 hours giving a report of the GD entry as well as not getting the authorization because of the urgency, that report they are not speaking of anything. There is no evidence regarding compliance with the provision of section 42(2) of the Act. Otherwise, authorization they could not receive. That is there. The rest, Lordship will see at the time of hearing 42(2) how far 72 hours non-sending will be fatal in a particular case. Karnal Singh says what? Karnal fatal. That we will have to examine, Lordship, during the time of hearing.
But it is palpable on the face of the record. It was not followed.
এইটো কোনে ক'ব পাৰে? 6 ক'ব পাৰিব নেকি?
6 to 6 লোৱা নাই।
6 নহয়, যিটো ইনভেষ্টিগেটিং অফিচাৰ।
এইটো দিয়কচোন মই পিটিশ্যন
কোনটো লাগে?
In cross-examination of PW6, he is saying that before proceeding to the house of Sri Rajesh Sarkar, the information was given to the superior officer, that is the circle inspector of the Pulibar police station, who authorized us to proceed to the place of occurrence in writing. That is there. In
That is there in his cross-examination.
Where is
I have
the
not submitted the authorization letter under 42 along with the charge sheet, but he, as per him, it was authorized. He was authorized by the circle inspector before proceeding.
But
that is there.
if they did not bring into the record, how the court will come to the conclusion? Then
But then
authorization is there.
But then again, the statements are contradictory. One said we have not obtained because of urgency, and one said this. These are again contradictory. Yes, contradictory.
Yeah, 40.
Actually, these police officers are not very clear with the provisions of NDPS. Problems arises there.
So this need to have a actually stations for their thing. In several occasions, I approached to the judicial academy also to have a such kind of training program, especially to deal with the cyber matters as well as the because the conviction or the sentence part is very stringent. So that's why
These are not technical and it matters.
technical.
Because superior officer will again not be a circle inspector. They'll have to inform the OC or SP or.
But the 5 is OC only.
But 5 is not OC. 5 is an attached officer.
In charge, IC.
He is the attached officer.
Oh, so he is
IC.
the IC. Okay.
IC.
Okay.
And he had given the information to officer in charge. We proceeded to the house along with other police personnel as well as officer in charge.
Officer in charge was there. Yes, along with them he was there.
I think when the officer in charge is there,
Yes.
authorization is not required.
Not required. That's
Not
what I am
required.
asking. Who was the officer? Authorized. The officer in charge was along with the team.
I think that will come under section 41.
Yes.
41 provides that if officer in charge is there, then it's not required for authorization.
Because he is authorized.
He is authorized. He is authorized.
Part Mr. You are Mr. P. Haldar.
P. Haldar.
Part Mr. P. Haldar. Also part Mr. MS. an application. It is submitted by Mr. Harper that there is a sufficient ground for the acquittal of the present accused appellant, and there is sufficient contradiction in the evidence of PWs. PWs which may be sufficient to for acquittal of the present. He further stressed on the non-compliance of the Section 40 of the NDPS Act, which is a method. Further, he submitted the learned court below also reflected in the judgment passed by the judgment that there was not the total compliance of their PC. The food sorted food of the NDPS Act with NDPS Act. However, considering the judgment of the Honorable Apex Court, as in Colonel Singh, wherein it has been held inter alia that in case of non-compliance of the Act, the trial may not be necessarily be initiated if the accused is not guilty. The Lieutenant Counsel Mr. Halder further emphasized on the position of PW5, that's the seizing officer, wherein he stated in his cross evidence that the information was received at 12 noon, and they visited to the place of occurrence for seizure and for the other formalities at 3:20 p.m. So the police station is only 14 kilometers away from Kulibar police station. Accordingly, he submitted that the police or the investigating officer had sufficient time to record for send in writing for seeking authorization, and to receive authorization under proviso of Section 42 of the NDPS Act. Accordingly, he submitted that on that count itself, the accused appellant is accepted for acquittal. Acquitted. Mr. Halder further that in the case of 26, the Apex Court in Para 5, it has been held that the non-recording in writing the information received, before initiating action, or non-sending a copy of such information to the official superior forthwith may not be treated as violation of Section 42. Full stop. But if the forthwith may not be treated. No, but if the information was received when the police officer was in the police station with sufficient time to take action, comma, and if the police officer fails to record in writing the information received, comma, or fails to send the copy thereof to the official superior, comma, then it will be a suspicious circumstances being a clear violation of Section 42 of the Act. More so, the father relied on another decision of the Apex Court, and the court was the case of Chagandal reported by 2014. But ada na passed by Division Bench in Criminal Act number 592, 2005, where in para 6 of the judgment it is treated as a further submitted that the persons more than features and the disposal of the failed case further more time, and considering this aspect of the case also, the evidence be released on tape that the that imposed on him. So and so. And in that regard, he also relied on the decision of the Honorable Supreme Court, reported by 2023 AIRSC 2022 2000 need relay করে পুটি দিব লাগে নহলে এনেকে 2026 SSC 150 Om Prakash Sahni versus Jaishankar Chowdhury and that from episode 5 and 6, it's in that it on at about 3:50. They rushed to the place of party. However, she submitted that in the cross examination of the 5. He stated that they committed to keep it on at about 12 noon. But he submitted that they no evidence that within the report was not submitted to the higher authority within 7 hours as required under Section 40 here at the NTPS. further submitted that cannot be to non-compliance of and there was uh, and and 0.5 specifically submitted report is that due to RGC the proper authorization obtained from the higher. However, from the record with that the though the authorization was not obtained from the higher authority, but the officer in charge of the concerned police station was also uh, was accompanied the seizing officer spot and in presence of thus the entire seizure was done in presence of the officer in charge. Officer accordingly submitted the presence of the in charge team. The authorization is not required and it is supposed to be the authorized officer to it is supposed to be the authorized officer for give permission for seizure. However, it is subject that there may be some contradiction in the evidence of the PWs, but that will be the subject to look into while hearing the matter at the time of final hearing. And accordingly, it is subject not of the case, but the 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 accused appellant can avail the can be allowed release on bail by sentence under the act. It is subject of it is recorded and the evidence is recorded by the started court. It is seen that the seizure and the other witnesses have supported the case of prosecution. However, there may be some sort of contradiction of the PW may be considered at the time of the case. The learned special judge observed in his in the judgment that there was not total non-compliance of 42 of the NPPS Act and considering the judgment of the Colonel Singh, judgment of the apex court passed in Colonel Singh Gupta, it has been held that the non-compliance of Section 42 of the Act, the trial may not necessarily be repeated if the accused is not no evidence is better. But most of it, no issue is raised with regards to the submission of report at or superior authority within 72 hours of the 72 hours of the seizure of the contract and from evidence of the fact that the as that was so the authority could not complete it, I think, of the higher that rate of return, and in the same time offer charge of the company the so accompany the the existing team to the death of the person. Thus, it also can that use the in time to record in writing or obtain the record of any higher authority before initiation of the custody. So, if in case of content in Supra, it is para 35 CND on this one that total non-compliant work the subject 1 and permissive permissive comma compliant with about the compliant what to what that's kept or goods or the goods or evidence being destroyed or comma not recording in writing the information comma before before initiating action or not sending of a copy of such information to the official airport comma may not be treated as a violation of the order. But considering the address subject so in the considering the discussion made in the above so considering the discussion made in the above cannot unacceptably establish the nature of nature and the establish the nature of education and period of sentence. I cannot find things to allow the to happen release on bail by suspending sentence and for extension. However, in that the record has already and is 48 and and shall be made to both of appeal within a short. No, the administrator will be responsible on the next. Will dispose of the matter on the next date of this thing. Will hear the matter. So your petition stands.
What is the fixed date for hearing?
That I don't know. It is a matter of 2021, but he is in jail. You are Amaka?
Yes, Lord.
Okay.
Legal aid council.
Oh, legal aid. Legal aid council. 13C. We are fixing on 13C. Yeah.
The observation made in this IA Lordship shall not be bearing on the decision arrived in the.
Okay. Because I have already. That should not be also. It's paper. Dispose.
May I please, Lordship? Lordship, as per order dated 22/4/2024, appeal has been admitted and admitted for hearing and LCR was called for. LCR is there.
So it can be fixed for hearing.
In due course.
Service complete.
Service is complete.
Yes.
44. Yes, to some. As Kakoti has already.
Yes, is there.
You are Mr.
A. Hassan.
Hard Mr. A. Hassan. Ilanet 44. Ilanet council for the appeal. So hard services already services completed. One MS Kakoti has already appeared for. Elsewhere has already been with this matter reporting for hearing. After 3 weeks or 4 weeks after. Is it 24 matters, huh?
Yes.
Just after 4.
Deep problem.
May I please, Your Lordship?
Yes.
This matter is related to appeal against acquittal, my lord, filed under section 372, my lord. Against the order.
Earlier admitted, or it's the first time he has come?
Yes. This says, my lord, notice may be.
Notice may be. How many private respondents are there?
One.
Only one.
One.
The informant.
Otherwise, state is there.
Yes.
It is against acquittal.
Yeah.
Then the number 2 is the accused. Right? Hard MS. You are MS?
B. Hazarika.
Hard MS B. Hazarika. So hard. Wait. Issue no. This recording. You take tips with it.
Oblige.
No, 46. Okay. You are on 46 also?
46 and 47.
46 and 47.
Lordship, my apologies, Lordship, due to some inadvertences, we couldn't provide the copy to Learned Counsel, who is also respondent in person. Lordship, give us 1 week time, we'll provide them.
Why you need 1 week time? I just can't.
Lordship, meanwhile, in the 1 week, we also take
copy,
steps, Lordship.
providing the copy, why you need time? That is the main thing.
due to some
Copy is with you. Appeal memo is prepared by you. Petition is prepared by you. So what is the... you can very well furnish the copy.
Yes.
Today itself.
By tomorrow, Lordship, we'll finish it.
By tomorrow?
Yes, Lordship. And meanwhile, we also take steps, Lordship.
You need to take steps. That's what I'm saying. I'm ready to
That's what
accept.
she's saying. That she is appearing in person and she is ready to accept the notice on behalf of the respondent number 2, who happens to be her
in
husband.
one item she can take, but in the second item 47, we'll need to take
Okay,
steps.
that is for the bank. And they should have taken it.
47 you need.
Yes,
you want to
their
take
respondent number 2 is the
750.
branch manager, Lordship. There will take
Branch
the-
manager.
Yes.
Okay, then you take steps. It's okay.
Regarding the
But provide the
46,
copy.
we'll give
Provide
them-
the copy.
So I can
By
file
tomorrow,
affidavit.
pardon?
if they provide the copies, I can file the affidavit.
Oh, yes.
Lordship, by tomorrow we'll give them copies.
If for that reason you don't need 1 week time.
Yeah, always.
She's waiting for their since anyway 46. 46, you are appearing in person?
Both 46 and 47, both are, I'm the respondent number 1.
Yes. 46, because Mr. You are Mr.
NZ Chaudhary.
And Chaudhary appearing for the petition. And also heard MS K. Sakya, the petitioner in person. Full stop. The further submitted that she is ready to receive the notice on behalf of the respondent number 2. And according to the counsel for the petitioner side is thereby asked to serve the notice to the respondent number 2 through MSK Sakya, the petitioner in person, the respondent in person. Further, MSK Sakya submitted that he has not received the copy of the petition in spite of the. Have you made any request, her? In spite of the request made by her? In this context, Mr. Chaudhary, the learned counsel for the petitioner, has submitted that by tomorrow itself he will submit the copy of the petition to the consul in person. So then it was in order column, I think.
Yes.
It is in order
you
column.
know the should be in order column itself, or you want to fix it in admission column?
So otherwise, LCR was also called for otherwise.
Yes.
LCR was called. Have you received? The LCR has not yet. If you remind that he distributed it. This is the matter accordingly. So how many for affidavit you need time?
We need a very short time. Tomorrow, if we give, within 2 days, we'll be submitting the affidavit. So,
but still 1 week
for
late.
for LSR, yes.
Should we fix it after 1 week?
Because LCR has to be there.
Yes,
and
for
then
10 days. 10 days.
10 days
LCRs
time?
will ensure.
Want any fix it?
Yes, my lord. Just say June. For orders, it could be also June 5th or 7th.
7th of June.
7th
Let it be not 7th of June. 7th of June, but LCR, I don't know. Will be ready? LCR will receive?
Usually, they will not take that long.
Let it be on 12, 13, 14, 6,
Okay.
because
12.
12 6. আৰু এইটো দেখিব আপুনি টুৱেণ্টো হাৰ্ড টুৱেণ্টো কৰিব ইছ্যু নটিছ টু দি ৰেছপন্সিবল also call for the healthcare distribute it in the meantime same depot that provide the copy of it to the petitioner in person to the respondent in person. MS is like same order, not with same order. Here the issue notice to the respondent number. In other case, the respondent number notice to the respondent number will be personally received by the respondent number. Both the matters be listed on 12 of
on 12.
12 6. Okay. Both 46 and 40.
It can, shall we tag it with due permission of the court? Both the matters can also be tagged because it is related to each other. Although separate offences.
It can be tagged. No.
It can
Although
Please
separate
put it
offences.
this the matter 47 or you write 47 matter be listed along with criminal petition number 528 of okay it will be there.
If you oblige.
In 47, we'll take the steps for respondent number 2, Lordship.
Otherwise for 46
Yes, Lordship,
we can,
we'll give it to her by tomorrow.
we can
Much obliged.
48 to operate 48 48 Both are 2008 matter.
May please, Your Lordship. Analogous criminal appeal 137/08 is not listed. Their name has not been shown in the cause list. That's why our item is remain in the record is there, but in cause list has not shown Mr. name of the Mr. P. Kotoki. That's why I asked for adjournment for today, showing the name of Mr. P.
Counsel for the appellant's name was not shown.
Along with these two, another matter is there.
Yes, another matter.
Analogous matter.
Analogous matter. 137.
Otherwise, those matters were listed together earlier?
Yes, my lordship. Yes. Already record is there. Same matter. But our name
But today, Lordship, 137/08.
137/08.
Lordship.
This is also criminal appeal?
Appeal.
It's not listed today.
137/08.
Listed, but council name is not shown now.
So anyway, about other two matters, what do you want to say?
Today,
Our party said ask for adjournment.
Lordship,
Our party?
They want adjournment.
130.
You want adjournment?
Yes.
Lordship,
Submit clearly.
Lordship, analogous matter already. Lordship, our matter is today's adjournment.
Now see, these are the 2008 matters in fact. So, I don't know. Mr. Haloi.
Okay, I have always an objection, Lordship. The old pending matter, Lordship. This I leave up to Honorable Court.
Lordship, date may be fixed, Lordship, on that. Today.
Actually, why these old pending matters come in Wednesday? It should be Thursday or Wednesday so that priority can be given on for hearing matters.
Yes,
now list is 52, 53 matters are there.
Right.
So now at the case of 330, these matters have come.
That is the difficulty.
That
Every
is the
time.
difficulty. It should be. I'll try to talk to the registry people also. These matters should be given a priority, in fact, because there are 2008 matters.
Right.
Now see, who you are going to Arguti matter, or who is your engaged counsel?
P. Kotoki and DM Chaudhary, I think.
DM Chaudhary was there.
And my senior is Mr. D. Talukdar, Lordship. 49.
For the item number 49.
Yes, Lord.
Thursday list is tomorrow is Tuesday, what is the date?
Lordship, this month, Lordship, till the end of the last week of next month, I am not free, Lordship. All cases are fixed, Lordship. Till the end of, June.
I mean, 4th or 6th June will not be confident.
No. Already fixed matters are there.
Please tell of 137, give me like 130. No, what? It's two matters which are happening. Other Apple. You offer a respondent.
Respondent.
Adjournment for review. These three matters along with criminal appeal 137 of 2000. So as per your convenience, what
the last week of June, Lord. Last week of June. So there is one matter on 25th, I think.
27.
27. Let it be on 27.
27 June.
27th of June.
The hearing.
But
Hearing
the question is that these are all 20. No, hearing day. You see, hearing day.
Hearing day.
It's a hearing day.
27 is a hearing day.
Hearing day. Just remind us in the morning hours so that at least it can be started by 12:30 or 12.
Right. This matter will take otherwise time. It will take time, Doctor. So voluminous.
Take time. Suppose it may continue for
1 to
second or third day also.
Yes.
So at 2 it can be, if it can be started, then we'll steer because in the hearing column.
Right.
2008 only. Then list it 27. 27 of You were not there in the Rakesh Pal matters. You were not there.
I was not there. But tomorrow we have one matter that tomorrow it was fixed to talk to that telephonic conversation.
Oh.
That was fixed tomorrow. That matter.
Telephonic conversation matter is fixed tomorrow.
Tomorrow.
Okay.
So I'm preparing. Let's see what can be.
Today is Thursday. Tomorrow is Thursday, na?
Tomorrow is Thursday.
Okay. This telephonic conversation, Rakesh Pal, the Mr. Thakuria, the special judge, even he is not getting his transfer order because of the penalty of those matters. One SI scam, and other one is Rakesh Pal scam, whatever. So those two Rakesh Pal matters too were with me. In fact, so I have passed the order that it's gone to Supreme Court. Most probably it was SLP was rejected. I think.
But in special court, apart from these two cases, I was there also as a special witness. Now I quit lottery. I quit that job because CBI only. I am the only PP here, and the voluminous records are very voluminous. And every day, your see the cause list. 5-6 cases are listed every day.
Yes.
And I'll have to go by the record only.
In 3 courts you are appearing or?
All the courts. Wherever the matter comes, wherever the matter listed, I'll have to appear. That is the.
Who is the other counsel in fact?
Other counsel is Subhash Kyle.
Oh, Kyle is there, yes.
Kyle is there, but he was not allotted any case. Initially, he was the counsel. But something has gone wrong with him. Therefore, that is the difference.
Okay. Now you are the only counsel.
Yes, I am the only counsel. The whole pressure is upon me. I wrote to the department.
So all the matters are very voluminous and all.
And serious. All the matters are very critical. Lord.
It's very critical.
Very critical. You have to go to the judgment also and the voluminous records also. Lord.
Yes, voluminous record.
But if I stay here till 4:30, no time to refresh and all. Lord. Again, I will have to go through the records of the case and come prepared for the next day.
So you are not giving time to your family also?
No, not time to the family and not time to myself. No
Same
time.
with
Lord.
us also.
Yes. I'm deteriorating my health. Lord.
Sometime at least.
Okay. I'm deteriorating my health. Lord. My sugar level and all has gone high now.
It's fluctuating.
Lord. That is the difficulty.
What about Ms. Dahan? You are also intense, I think, na?
Same with all advocates perhaps.
No, you have some other tension also. Apart from this job prior. Let us hope maybe.
Yes.
If you do for the election matters also, it may not. I think the order was not there. I think whatever.
I don't have any information. Whatever.
Okay, it will both the matters will be listed on 20. Both not all the 3 matters will be listed on 27/6. That time.
Okay.
Aliv.
Okay. Goal koi kota. Oh, 50 here. You are in 50?
Respondent. Private
respondent.
All along I was waiting for the case. Now the counsel is not there.
He was there.
No, I think he.
Mr. D. Saikia was there. Devin
Saikia.
He is not here right now. The petitioner, the appellant, not called. Heard Mr. B. did not account for the one, and also heard MS as list the matter accordingly. After 2 weeks or 3 weeks?
After 3 weeks.
After.
And in the meanwhile, memo of appeal may be provided to me.
Oh, yeah, it's not yet provided.
No,
it is submitted by Mr. The memo of appeal is not yet provided by the appellant. Appellant is accordingly that provide the memo of appeal on or before the this recording.
Lovely.
Okay. No 53 there.
2023 matter.
None appears on call for the appellant. This accordingly after. tomorrow also that matter is now Mr. Halloway is saying. On that day, I heard the matter from most probably 10:40 to 4.
Same matter.
One matter only.
Acha, acha.
Since 10:40 up to 4.
Oh.
Till then, it is not over. 3 sets of advocates are still there.
Oh.
For tomorrow, it will fix.
Oh, yes, I remember those cases where Delhi Council came.
Yes, Delhi
yes.
Council.
Oh, tomorrow that matter is on board.